and the way in which we interact with each other in business. Can someone help with those lights, please? There. Thank you. The way in which we interact as humans, etc., in business has changed, and it continues to change. And so that brings me to the point of labor law in Nigeria and what we're doing here, reimagining the workplace. We've seen a significant evolution of labor law in Nigeria, primarily thanks to the work of the National Industrial Court. And we expect that, but beyond the National Industrial Court, there is a place and there is a large expectation that our National Assembly and the state assemblies would have evolved laws that actually reflect human interaction, human and business interaction in society now. So this conference is really about the role that labor will play in it. So I thank and commend the Employment, Labor and Industrial Relations Committee for organizing this conference. I look forward to robust discussions from the wonderful panel that we have here. And I wish us all successful deliberations. Thank you very much.
Thank you very much, Mr. Chair. For those of you online, we are trying very hard to resolve the audio difficulties I understand you're experiencing. Next is the welcome remarks by the chairman of the committee, Mr. Ose Okweko.
Good morning, everyone. It's still a mystery that after so many years, Mary still struggles to pronounce my surname. Mary, I will forgive you on this occasion. Please permit me to stand on existing protocols. Although not on all social protocols. Over the years, something funny had happened. I woke up in the morning on a particular day and I got a message, Happy New Month. So I was like, right, okay. And then I was okay with it for a while, and then it became Happy Sunday, Happy New Week. I kept wondering to myself, when are we going to end? And then at a point, it got to, how was your night? At that point, I had to draw the line. You don't want to know how my night was. There's a difference between, I hope you slept well, and how was your night? And so it became a personal social crusade to try to enlighten people as to the difference between how was your night and I hope you slept well. And you won't believe what I've had to go through trying to do this. So I will not stand on that protocol. I will choose another protocol to stand on. And so these days, when you're on LinkedIn, you hear, I'm happy to announce that I've got a new job. I'm happy to announce that the SBL chairman just bought a private jet. I'm happy to announce. So on that, I will stand on that and say, I'm happy to announce that we are back to our physical conferences. It's been 2 years of COVID-induced virtual conferences. And so we are happy to be back physically, and we are happy to have our first conference outside of Lagos. And it's a privilege to be in Abuja today, and we are hoping that Abuja people will still turn up in mass like they promised they would. On that note, I would like to welcome everyone to this year's conference, and we have carefully selected the theme for this year's conference: Reimagining the Workplace. And truly, do we need to reimagine the workplace? Should it remain the way it is? What can we then do if we intend to reimagine the workplace? Can we reimagine the workplace without looking at the principal legal framework, which to a very large extent, it still creates a double jurisdiction as to who it applies to and who it does not apply to? Is there a need to actually tinker with the Labor Act as it is? I mean, in the light of the current situation that we find ourselves, the great Japa, how do we begin to deal with some of these issues? And so we have carefully curated 3 very interesting topics to be discussed today. One of them is the Great Resignation. I don't know who has not been affected. As at last week, Tuesday, at the 65th Founders Day of UCH, the Chief Medical Director, Professor Oyebajo, mentioned that between June 2020 and October 2021, UCH had lost 651 medical personnel. And they were all lost to Canada, UK, and the US. And in his view, we will begin to feel the impact in 5 years. But I disagree. We're actually feeling the impact now. I don't know any law firm, using law firms, that has not lost employees to the Great Resignation, either leaving the country or joining subjuditional fintechs. And so the effect of the Great Resignation is currently being felt. I am feeling it. I'll give you an example. The Assistant Secretary of our committee has jackpot as well. So the committee is actually feeling it. So I mean, quite apart from my firm losing some people, and I know a lot of firms who have lost people, our committee we lost our Assistant Secretary, Bayo, to the great jackpot as well. So it is something we need to begin to discuss. Is it a threat? Are there opportunities there? What can organizations begin to do to manage the situation? And recently, just to test the waters, I did a paper on maternity leave, whether it is actually annual leave consuming. I've had experiences trying to provide advisory services where organizations have said to me, once you take maternity leave, you are not entitled to annual leave. I put out this paper, and the kind of reactions I got, it was really amazing. It then occurred to us that truly, perhaps, still a lot of people don't understand the concept of international best practices. So on that basis, we've brought together judges from National Industrial Court, HR practitioners, and legal practitioners to then discuss and maybe throw more light on the concept of international best practices. Then the big one in the room, we then have another subtopic to look at the issue of reimagining the workplace using the Labor Act as a tool. So we'll have seasoned practitioners sit down and discuss truly if there is a need to revamp the Labor Act. I think this makes for interesting conversations, and I'm looking forward to these conversations, and I have my own questions. So permit me, panelists, to ask my very difficult questions. And these are difficult conversations that we must have. Having said that, I would like to say a very huge thank you to the organizing team for putting this together, and more importantly, to the leadership of the SBL, past and present, for all the support. Gio, even before he became SBL chairman, has always been one of our biggest supporters, and so we are very grateful, Doctor, that you are here today to even give the opening welcome address. I would have loved for the National Industrial Court to be, judges to be here. The NIC has been awesome. They've been very supportive in everything we do. We are grateful now that we have Ministry of Labor here with us, and we are grateful that they are beginning to collaborate with us, and we will collaborate more with the Ministry of Labor. But just to say that I don't think sometimes the Obasanjo administration gets as much credit that it deserves, because most of the changes that we are seeing today have been driven by the National Industrial Court, and that was only possible because of the third alteration that was done by the Obasanjo administration. And so, I mean, we are eternally grateful to Obasanjo and his team for putting that together. I would also like to thank members of my executive team. Afolabi Kuti, SAN, thank you very much. Mary Ekemeze, thank you very much. Ifeoma Ota, who is unfortunately not here today, and Bayo, who has jackpot. If you are online, thank you very much as well. It's exciting times. I am very positive about the position of and the role that employment law will play in the coming future, in the coming years. And I think we are poised to do more for the sector. And on that note, I would like to say thank you and welcome to this conference. And please, let's enjoy the conversations. Thank you very much.
Thank you, Ose. I hope I got it correctly now. So we do have, as Ose mentioned, the Ministry of Labor with us. We have the Honorable Minister of Labor and Employment, ably represented by Mr. Okechukwu Nwamba, and he will deliver the keynote speech, which really will set the tone for our conversations today. So it's my pleasure to welcome Mr. Okechukwu Nwamba to the podium. Thank you.
Thank you very much. My name is Okechukwu Nwamba. I am the legal advisor of the Federal Ministry of Labor and Employment. I am here on behalf of the Permanent Secretary of the Ministry. And she has asked me to deliver this keynote address to you. So I am doing it on her behalf. It's not going to be my opinion. It's not my opinion. So it's her opinion. So permit me to read it. And permit me to stand on the existing protocol, if any. I'm not going to toe the line of the previous speaker. So let me now read the address. It says, keynote address by the Permanent Secretary, Federal Minister of Labor and Employment, Kacholom Daju S. MNI, on the occasion of the National Annual Conference of the Nba-Sbl, Employment, Labor and Industrial Relations Committee. I am greatly pleased to be in your midst on this auspicious occasion of your National Employment Law Conference taking place today in the Federal Capital Territory, Abuja. I am particularly happy because your invitation to me is a living testimony of the bond of cordial relationship between your association and my ministry. This occasion, therefore, affords me the opportunity to fraternize with the executives of your association, section on business law, SBL, and indeed all other members who are here to witness the occasion, and those who are watching us online. As this is my first time of meeting with you in this type of gathering, I therefore wish to congratulate your national executive on their wisdom and vision in coming together to organize this all-important national conference with objectives of not only to enforce the professional development of Nigerian commercial lawyers, and I say here business lawyers, but also to influence government policy, engage and support law and policy reforms in Nigeria in particular and in Africa in general. By this, they have demonstrated the highest sense of responsibility and patriotism in the discharge of their mandates. This, therefore, marks the beginning of the new dawn in your association and also demonstrates your collective resolve to rebuild and strengthen your association to be able to achieve the objectives for which it was established. I thank God Almighty for making it a reality and for the privilege given to me to give this keynote address. Distinguished ladies and gentlemen, I note with interest the importance of this conference. I also take particular interest in the theme, which is Reimagining the Workplace. The theme is quite impressive and captures the minds and aspirations of all well-meaning Nigerians, It is most ideal and timely considering the hazardous nature of the workplaces. It presupposes a model of how people want to engage with their workplaces with a view to increasing productivity. Emphasis, therefore, would be placed more on the safety of workers, training and retraining in order to continuously meet the demands of the teeming Nigerians. There is urgent need for a synergy between the employers of labor and the workers to achieve industrial peace and harmony in the workplaces, which is a catalyst for increased productivity, the sine qua non for the growth and development of our country. Fellow comrades, as the preponderance of organizing these conferences, amongst other things, to discuss on the changing landscape and realities of our today's world of work, it is against this backdrop that I implore all participants to be very attentive to the papers to be presented by the resource persons who were carefully identified and selected to discuss the theme in the best globally accepted manner. You should also partake fully in the deliberation as your incisive contributions in this conference may be the secret solution we need to be able to navigate the emerging realities of our new workplace. It is in this regard that this conference becomes very imperative. All hands must be on deck to ensure its success. And I have no doubt in my mind that this conference will ultimately provide a veritable platform for experience sharing among the participants. Once more, I welcome you all to this memorable conference, and I wish you deliberation, safe returns to your respective destinations. Thank you and God bless.
Thank you very much, sir. We will now proceed to the first panel session of the day. I will call on the moderators of the session, Mr. Jamiu Akolade and Mrs. Natalia Odidika Esesobo. Yeah, I got it right. So they will introduce their panelists. We have 4 distinguished gentlemen actually on their panel. We've got Esiagele Agwele, who's the CEO and co-founder of Verify Me. I know, I murder your names, I apologize. And we have Ugonna Obuagum, who's a partner at Alex. And we have Emmanuel Abraye, a senior associate with Paston and Grace. And Mr. Thompson Akpabio, the director of NECA, he will join us virtually. Jamu, you know, how else will I remember I'm in Nigeria if everything was just going smoothly? Sorry, my apologies. It's a rude awakening as usual, but this will be sorted out in no time. Exactly. Jamu, Natalia, over to you.
Thank you, Mary, and good morning, everyone. My name is Jami Akolade, and I'm one of the moderators for this session. We have two of our panelists online, but I will invite those who are on ground to come with us on the high table or the panel, as the case may be. So, Mr. Emmanuel Abraye and Ugona, please step up. I'll do a brief introduction of the panelists. Natalia will also do part of the introductions. But I'll start with the man I can see on the floor first. So Emmanuel is a good colleague. He's the team lead of the labor and employment practice in the commercial law firm of Perchstone and Grace. And since he's okay. So Emmanuel qualified to practice law in Nigeria in 2015, and since then he's garnered such a wide spectrum of experience in labor and employment law, of course, banking and finance, and basically the whole spectrum of commercial law practice. He's also a prolific writer, has written several articles in the subject area, is a contributing author to many employment law publications, including the popular Employment Law Review, which is a UK-based publication reviewing employment law practices across many jurisdictions across the world. And of course, he's a member of our committee, the Employment and Industrial Relations Committee of the Nba-Sbl, and we're glad to have Emmanuel this morning to be part of this panel on Reimagining the Labor Act. Welcome, Emmanuel. Mr. Thompson Akpabio is online. Mr. Akpabio is a lawyer, a charter secretary and administrator, and also an industrial relations and HR practitioner. So he wears many hats, multidisciplinary experience. He's currently the deputy director and handles the legal affairs of the Nigerian Employers Consultative Association, which is the umbrella body of employers in Nigeria. Is an alumnus of the University of I'm sorry about that. University of Uyo in Akwa Ibom, where he was qualified to practice law in Nigeria in 2002. Mr. Akpabio has been involved in legal practice, working with such reputable law firms as Chief Ape Babalola's SAN's firm in Ibadan. He's worked in Port Harcourt, and now he works with NECA, where he's helping to dial some of the tension in the employment law space by speaking on behalf of the employer. So his perspective from the employer side will be very, very valuable for this session we are having. Mr. Akpabio, I can't see you, but I know you can see me. Good morning, and we're glad to have you on this panel. So Natalia, I'll ask that you please introduce my good friend Ugona and Mr. Esige on the panel. You can use your microphone.
Good morning, everyone. Okay, so I will be introducing two people. One is online and one is here physical. So I'm going to go like Jamu and start with Ugona, who is here. Ugona is a partner in Alex Dispute Resolution, Labor and Employment, and Tax Dispute Practice Groups. He routinely advises clients on labor and employment matters arising from complex commercial transactions such as acquisitions in the healthcare, infrastructure, FMCG, insurance, and industrial sectors. He regularly supports clients, particularly multinationals, in workplace audits, including review of employment contracts, office handbooks, procedures, and policies to ensure compliance with statutory, judicial, and regulatory standards. He also advises and supports foreign clients in compliance with Nigerian immigration procedures and requirements. Ogona has significant experience in labor and employment litigation at the National Industrial Court and the Appellate Court. He is a member of the Employment and Industrial Relations Committee of the Nigerian Bar Association on Business Law, Section on Business Law. He is also a member of the Employment and Industrial Relations Law Committee of the International Bar Association. He served as a member of the Commercial Law and Taxation Committee of the Lagos Chamber of Commerce and Industry in 2020. Ogona has been ranked by Legal 500 as a rising star in dispute resolution and by ITR World Tax as a highly regarded individual in tax controversy. Let's welcome Ogona. Thank you. Okay, so I'm going to move to the other panelist who is online, and that's Mr. Sige Aguele. He is the co-founder and chief executive officer of Verify Me Nigeria. He is at the forefront of driving financial inclusion in Nigeria and Africa by building products that connect businesses to trusted identities and customer analytics. Prior to being the CEO, Sige was chief operating officer, building the operations infrastructure from ground up. Since its inception in 2017, Verify Me has become a leading KYC startup in Nigeria and now counts 60% of Nigeria's commercial banks amongst its customers. As a leader in the identity ecosystem, Verify Me co-developed an inaugural 2022 industry report with Dalberg Advisors entitled Digital ID in Nigeria, the State of the Industry. Sige is a seasoned enterprise architect and business transformation expert with almost 20 years of experience in building products and enterprise architecture across several sectors, including telecoms, banking, and aviation. Prior to Verify Me, he was a portfolio manager with Mantech International Corporation, an international engineering company. At Mantech, Sige reported to the chief operating officer and managed a staff of about 80 engineers and senior managers. He was responsible for priority enterprise and solution architecture programs across US government agencies related to business transformation, where he led programs to align with agency mission, business architecture, and IT assets. In 2012, Sige led and delivered the technical reference model for the US Veterans Affairs, which manages the technology roadmap for the 140 billion agency. Let's welcome Sige, please. Thank you. Jamil, over to you.
Okay. No, I'll use this, but I think they might need that. Yes. Okay, so I'll just do a quick introduction of what this panel discussion is about. So, of course, I mean, almost everybody has heard about the Labor Act, and it is really the primary and main legislation we have when it comes to labor and employment law in Nigeria. It is an act that's probably the most discussed legislation in the subject matter area, and for good reason. It's the foundation of all minimum labor standards in Nigeria. And unfortunately, it's a 1974 act, if I'm not mistaken, and we've struggled over the decades to even have one amendment. Several bills have been pending at the National Assembly, but we're still stuck with that Labor Act. So we're thinking, in the absence of an amendment, we've had the National Industrial Court try to find a workaround the seeming inertia of the legislature to make the Labor Act work, give life to it. And we just want to see how we can make the best use of the Act as it is. Is there a way we can reimagine the Labor Act, both in its adoption, its implementation, and maybe reading the provisions of that Act in another way, giving it interpretative efficacy? Is there a way we can reimagine the Labor Act to achieve its core purpose, which really is to assure basic minimum employment rights to workers and throw Nigeria into the league of nations that its workers enjoy the notion of decent work? So we have a great panel that has been introduced, and we will be sharing ideas with them on so many areas of the Labor Act and see how we can move forward the conversation beyond the problems and get into solutions mode. So the first question really will go to Mr. Akpabio, and following from my introduction, Mr. Akpabio, there's been so much talk about the inadequacy of the Labor Act. As a stakeholder in the sector, from the employer side, do you think that viewpoint is totally justified? Is the Labor Act totally inadequate? Is it a little bit adequate? Or you think it's just fine as it is and we just need to look at it from another angle? What are your thoughts, sir?
Good morning, everybody. Can you hear me? Maybe I can get a knob or a sign or something to know that I'm audible.
I think you may need to speak up more.
Can you hear me, sir? Can you hear me, sir?
Yes.
Am I audible? Thank you so very much. First, I bring you greetings from my DG, Mr. Wallace Matoyerinde, DG NECA. And we also want to say thank you for having us participate in this very important discourse. In your opening speech, you alluded to the fact that our Labor Act is since 1974. And it would take a census round the room, even where you are seated, and the bulk of the people on this call joining virtually. I think that 1974 is older than some of us. And that being the case, is no gainsaying that the law is outdated, is obscure. Now, being lawyers, as we have in this call, and on this panel, and in this particular engagement, you will agree with me that our laws need to be reviewed periodically, maybe 10 years, and on and on. So when you are applying a Labor Act that has been in existence since 1974, almost 50 years, then you begin to look at some of the provisions. For instance, if you look at some of the provisions, you'll be talking things like still 1 naira, 10 naira, and look at certain other provisions in the current or in the extant act, you will discover that the act has been left behind due to new emerging international trends, whether at the ILO or recent pronouncements from the NIC, or recent happening even in the world of work. And so there is need for it to be reviewed. We totally agree with that. So we do not support that the act is fine in its current form. Having said that, sir, we'd like to let us know that steps have been taken, even by social partners. What I mean by social partners, I'm talking about the Federal Ministry of Labor and Employment, the NLC, Nigerian Labour Congress, the Trade Union Congress of Nigeria, TUC, NECA, and even with technical support from the ILO in the reviewing our extant labor laws. I'm not just limiting it to the Labor Act, but I'm saying labor laws because this includes things like the Trade Unions Act, the Trade Dispute Act, the Trade Union Amendment Act, and even the Labor Act and the whole gamut of labor and employment laws in Nigeria. NECA was part of the discourse, and I was privileged to lead the delegation on behalf of employers in Nigeria. And we had several meetings, both in Lagos and Abuja. And we had recently concluded our review, I think on this August 2022 in Abuja. And what was agreed was that yes, this is a draft. The Federal Ministry of Labor and Employment will send it through, will prepare a memo where it send it to Federal Executive Council, FEC. From there it will go to the National Assembly as an executive bill. Thereafter, the legislative activities will commence. We had, in our review, drew the attention of all social partners to the fact that certain provisions need to be completely removed, and there will be need to introduce certain provisions so that we'll be in line with international best practice, current trends, ILO conventions, treaties, and even with the recent innovations which the NIC had actually brought to bear in our labor law jurisprudence. So the way it is now is that the whole lot of changes will be coming in. Not just from the title of the Labor Act or the Factory Act or the Trade Union Act, not just from the names or the titles, but even up to the content and its implementation. So what we are really waiting for is to know updates. I'm glad that the legal advisor of the Ministry of Labor and Employment is on this call. I saw him make a speech a while ago. And one of the things we will be expecting is that by now, the ministry would have done the needful, and then he will be able to guide us as to where the current, or what the current position in terms of those bills, whether they are the FEC or whether they have actually gone to the National Assembly. The need to review this law is not something that we can debate or just talk about or sweep under the carpet, because there's a whole lot of things that have been done. And a while ago, I saw Elena Silk, Kuti SAN, and I think he was at the very first leg of the review. He just strolled in when we were doing the first round of the review at the hotel, and he breathed in for about 5-10 minutes before being excused again. So he will also confirm what I've just stated in terms of our position in the review. So NECA, being the employer's voice, is quite pleased that this exercise is being undertaken. We only pray and urge that the National Assembly will give these bills the attention it requires so that Nigerians, employers and employees, and everybody will breathe a sigh of relief. The reason why we're talking about it this way, and passionately so, is because at the last ILO conference, there was a case reported against Nigeria in terms of unfair labor practice. And certain provisions of our law was being hinged upon, like, oh, let the Committee of Standards, let the Committee on Application of Standard, CAS, look at it, review it, get the social partners involved, the Nigerian government, which we have done recently, so that those things will be changed for good. I think I'd like to pause at this point in terms of my preliminary comments. So.
Thank you very much for that extensive background, Mr. Fabio. And I think that really sets the tone for much of what we're going to be discussing today. Like Mr. Fabio mentioned, I'm one of those people that the Labor Act is older than, and I'm sure if we were to take that poll, it'd probably be 100% that is inadequate. So we'll be dovetailing into specifics now to various areas of the Labor Act, both thematic and as specific as sections that we think need reimagining, to use the theme of this panel. So Natalia, I'll ask you to please go into the next set of questions.
Thank you very much, Jamil. So I'm actually also one of those the Labor Act is older than. Okay, so the next question is for Ugo. It's a good thing you are beside me here. So now the Labor Act, still on it, has some limitations, and that's one of the things it's been criticized for. It's been said that the scope of its application as it relates to workers is actually limited, is restrictive, especially as to define workers as persons who are employed for unskilled labor. Now, I have two questions really from this. The first is, would you subscribe to enlarging the scope to include all forms of employment? And then the second one is, what real impact do you think this will have on our labor sector? Thank you.
Thank you, Natalia. Good morning, everyone. For some of us or for most of us here who do prepare opinions for clients in other jurisdictions, it's usually a head-scratching exercise for them when your opinion is prefaced by the words. Our Labor Act only applies to workers and not to everyone. And then you proceed to make a distinction between who a worker is and who an employee is. And it's not surprising, because for people in those jurisdictions like South Africa and the UK, you find that the labor space is well regulated. It's clear that there's a plan to actually secure and protect the interests of many classes of employees. It's really a head-scratching exercise for them to understand why our Labor Act should be so limited. Reference has been made to the fact that the Act itself is very old, and that might be the reason actually why the Act is structured the way it is, why it focuses on unskilled workers. There are very few people here who can speak to the conditions between 1971, when I think the Act, which is the effective date, I suppose, of the Act, and I think probably a few people like Mr. Roland Otaro, might recognize that at that time, we had just come out of the Civil War, and this is me strictly from the history books. This is me speaking strictly from the history books. So at that time, this was just post-Civil War. Oil had just been discovered. We probably didn't have the kind of skilled employment pool or labor pool that we have now. So I suppose at the time, there might actually have been good reason for there to be focus on a lot of the pool at that time who would represent unskilled labor, which then meant, of course, that there was less focus on the other parts of the pool, which are the people who carry out what we always refer to as administrative, technical, and management functions. Of course, since that time, a lot has happened in this space. Technological advances, economic growth and recession, as it were, education, a lot has happened that has changed the dynamics of the labor market. In fact, for some of us here, the labor market or the labor system that we have now, post-COVID, was probably different in 2019 or 2020 post. There's a lot happening now that we didn't think was possible. Post-COVID, I hadn't been made partner in my firm, so I could say I'm still an employee, but I was, a much more standard employee at the time. And, hearing that we could work from home, that remote working was possible, and I think these were things that we never contemplated when, we were called to the bar, years much earlier. So clearly, a lot has happened that does not fall within the spectrum of the Labor Act. So if I sit here and say, in my view, that there is no need to expand the scope of the Labor Act to cover all forms of employment, many here will think that I'm speaking bulaba and balabu, because it's clear that we need to, ensure that everybody is captured under that, under the spectrum of the Labor Act. We have the unskilled workers, we have the who we can refer to as the skilled workers, but over time we've also had forms of atypical employment, employment forms that are not standard forms of employment. So you have, part-time employees, you have employees for fixed terms, you have casual workers, you have remote workers, you have people who are subject to ambiguous and non-contractual forms of employment. The truth is there has to be, a legal framework that captures all of this.
Maybe. But I think we got the gist of your response, which is we need to enlarge that definition.
Yes.
And bring in all forms of employment as much as is possible.
Yes, and just to conclude, I mean, there was a second leg to that question, which is the impact. And really,
Yes.
the key impact is certainty, right? Because, you know, I think there was an opinion I read that had been done to a client, and the response from the client was that this response is so equivocal that he's not even sure what to do, right? It's not clear what steps he will take, you know, and of course we put everything subject to determination by the NIC and all of those things. So I think the key thing is certainty for everybody involved, security for the workers, certainty for the employers of labor, certainty in the space. I think if we have a robust, you know, legal regime that takes care of all of this, and of course, as you mentioned, the Labor Act is the primary, you know, focus, or should be the primary focus of the labor and employment space. So we should have a robust act that actually deals with all these different issues and just makes sure that everybody is properly gathered into that umbrella.
Thank you, Gona. I think, I mean, during the course of the conversation, we might be calling on the representative of the Ministry of Labor because of their key role in addressing some of these issues. I know there are a lot of interventions that are going on right now, and it would be good to get their perspective on what the ministry is doing with regards to the review of the Labor Act and other legislations. Like Mr. Akpabio mentioned, I think, was it last year or 2 years ago, the Minister of State for Labor sent out a memo asking for proposals or suggestions on amending 4 principal legislations. But we'll get to that. You mentioned skilled labor in the course of a presentation. And I think the only person on this panel who requires a lot of skilled labor will be Mr. Esigie. And post-COVID, we began to, well, was it post-COVID or before then? I think one of the main issues we're facing as a country right now is the mass migration of skilled workers to other countries, presumably more favorable climes. And it's been so pervasive that it has led to the creation of a new word. We call it Japa, which is just to escape. And it's really a problem for businesses, as we know. So, Mr. Sige, do you think that the issue of skill shortages is something that regulation can help address, or is it a normal phenomena that we should just allow play its part? If it's something you think legislative intervention can help with, how best do you think businesses like yours and the regulators could work together with government to stem this tide and ensure that our labor sector retains a very skilled pool of talent?
Yes, thank you. Very happy to be here. Hello, everyone. It is a significant problem we're facing right now with the advent of so many people, skilled workers, leaving the country and moving out. One of the things is it's also like where I would say in the perfect storm because it's really as a result of issues beyond the control of companies like Verify Me Nigeria. A lot of the young folks who are leaving, have aspirational dreams that they feel they may not be able to attain in Nigeria because of maybe some conditions in the country. So the first thing I would say, that's going to stem the jackpot tide is really, maybe an overall better living condition that provides some sense of, better hope to people. And it's really, the only thing we can do about that really is for all of us to, get involved in our government to continue to improve conditions. But really, the JAPA is as a result of it. Do I think that there's regulation that we can put in place? I really do not see how we can put regulation in place. What I see that we can do perhaps is the government can help put interventions in place. Because, as a free country, people are allowed to pretty much leave and do what they want to do. But we can put interventions to potentially make it more enticing for skilled workers to continue to stay in Nigeria. We should put interventions, for maybe young people, maybe if they had better safety. I can tell you, for example, because people work from home, I've talked to very young developers, for example, and this is just an example of JAPA who, left the country, and they even went to places like Kenya and Ghana because, and they were doing well here, working remotely and making dollars, working for international companies. And I asked them, I said, why did you leave? And this is a true JAPA story about something beyond your control as a business. And it was like, well, in my neighborhood, people were making me, and sometimes even, officials, log into my app and transfer the money out of my account, and there's nothing I can do. That had no safety. And where do you go? So they're really serious there's serious environmental issues that we really need to face. The other day I posted on Twitter is we should not create conditions that push people out of the country, literally. And, because what they're going to do is they're going to look for a better life. So that's actually the first thing that we need to stop. Now, onto things in our control. Interventions, maybe we can look at how we can provide, tax reliefs, maybe programs for, buying homes or quality of life improvement for people that the government supports, because it's a real national security issue when you don't have people to build your country. We talk about doctors leaving, which is really a critical issue, but also when the engineers are leaving, right? The engineers are also, keeping a lot of the equipment that the doctors are using up. Or, the other day we had payment issues, and, our partner, the bank, is like, we're so sorry, all our engineers have left, the payment system is not working, it's been failing, and we're, trying to patch things together. And the government needs to look at it as the possibility of crumbling systems, right? And really get together in an emergency way to deal with this situation of JAPA in Nigeria. Now, the final thing I would say about that is, from an infrastructure perspective, another thing we can do, and Mr. Go, I think, talked about safety, is that when we look at the labor laws in Nigeria, we also need to look at how we can put in measures to create safer work environments. So, for example, the concept of making sure verification is done. We also have so many, issues with this, where people are not safe in their environment because companies are not doing proper reporting. So people who commit, even sometimes, crimes in other places, can just waltz into another workplace, and there's no verification infrastructure. So as even the government looks at e-government, looks at the use of NIN, which is our Nigerian identity number, we should also be looking at how to leverage operators and companies like VerifyMe to help the hiring industry in proper verification process. So not just identity, but even being able to share additional data so that employees who are doing their work can be safe, also from people who, and so that we can, I would say, remove people who shouldn't be in that environment from the work environment. Thank you.
Thank you very much, Mr. Sigi. I think you've given quite a number of things for us to think about. And I guess the government is also thinking along the same line. We recently had the Startup Act, which I think tries to give some incentives to emerging companies. But we'll get to more of that later. Nathalia, you have more questions.
Yes, this question is directed to Mr. Manuel Abraye. So, in the past it was quite, easy to define the relationship between the employer and the employee, but that's becoming a bit difficult considering the new work emerging from different angles. Example, like the platform works, agency work, and the rest of it. So looking at the Labor Act, the way it is, what do you think is the best way this can be accommodated? Thank you.
Thank you very much, Natalia, and good morning, everyone. Well, so currently today we have forms of work that are not what we are ordinarily used to. The Labor Act, for instance, creates a relationship between a worker, the worker's employer, and then, of course, the contract of employment itself. But we are having situations today where people are employed, in quotes, but they are not exactly employees. And like you said, platform workers, for instance, and you have them in a situation where they have to provide the work, but they don't get to enjoy the benefits of being called employees. Of course, we are all aware of the case that was litigated up to the Supreme Court in the UK against one of the ride-hailing companies. And in that case, the Employment Tribunal had held that, look, these platform workers are employees. You cannot, tie them to be called independent contractors. And by that, you shield yourself away from certain responsibilities that you should ordinarily have towards them. The ride-hailing company appealed to the Court of Appeal in the UK. The Employment Tribunal's decision was upheld. They appealed further again to the Supreme Court. That decision was upheld. But you have a situation where it's not the same everywhere. There was another case in Australia where the court said, look, no. Oh, I'm sorry. I'm sorry. And so you also had another case in Australia where the court said, look, no, they are not employees, they are independent contractors, And we had a situation like that in Nigeria. Unfortunately, the case really didn't see the light of day because pleadings were a bit faulty and the case was dismissed, but there was Oladapo versus Uber Systems Nigeria Limited, which would have, given us, what would have expected to see, But the Labor Act as it is says, okay, you're a worker, right? And even limits who you can define as a worker. Mr. Oguna has, given the reason why that must have been, especially because the Labor Act came, quite long ago, Now, what then do we do in a situation like this? Of course, we see what the National Industrial Court is doing. We just have the reality on ground is really just that companies are leveraging what the environment, is presenting to them. So you had a situation where before it was really just slave trade. Then enactments came and said, look, no, they have to be workers. Then you had, fire your boss, why should you have a boss? You can be your own boss, And so you now had people who now evolved into who Jacques Peretti called precariats, because they were in very precarious situations, living from hand to mouth, but being one-person corporations, And, I was in one of the, of course I can't mention the name, but I took a ride recently, and the driver was complaining to me about how he can't decide for himself who he picks. And that if, for instance, you, as a rider, tell him that you want to go to a place where, for instance, the roads are bad, he cannot do anything about, refusing the trip, because if he does, his driver ratings will drop. And then as his driver ratings continue to drop, he might get blocked off the platform, right? Now, that platform provider is exercising some form of control over that driver, even though they want to say, oh no, he's not our employee. The platform itself has employees who are enjoying certain kinds of benefits, in fact, stupendous benefits, right? But the driver is, called an independent contractor. He's not entitled to all of those benefits, So we need to come to a point. Of course, I know that Section 91 of the Labor Act in defining an employer, did quite well, in involving the agent of, whoever that employer is, involving the personal representatives of whoever that employer is, because sometimes you have very real scenarios where, for instance, a joint venture has been set up, 2 different companies or 3 different companies are together, and you have employees just rolling around these companies and really cannot say, who their employers are, and, when the, purpose for which the joint venture is set up is established, everybody goes home, nothing, for it. So we have to come to a point where the Labor Act has to redefine who an employer is, redefine who an employee is. Of course, we have other legislations that define these things, but, still they do not really take into cognizance what the reality of, work today is, of course. And having some of these decisions we have from, different jurisdictions, enlarging this scope of who an employer should be, or who an employer should be, an employee should be defined as, we can actually key into this. And, bottom line is that the Labor Act as it is does not cover all aspects of the current workplace. And employees who should rightly be defined as employees, of course, the National Industrial Code has always, looked at the primacy of facts when it comes to events like this. And of course, there's also the control test. Who is exercising this control, And you cannot remove all of these incidences, from defining who the employee is or who the employer is, and who liabilities or responsibilities should go to, in situations like this. So I feel that the Labor Act, or I believe the Labor Act, has to be amended, especially in clearly setting out who the employee is, who the employer is, properly defining these terms to cover all of these new types of work to ensure that employees are rightly protected. Thank you.
Okay.
Thank you very much, Emmanuel.
Yeah, so Emmanuel, while you were speaking, I was just thinking in my head, when you look at the fact that, so this is me exercising the moderator's power to ask my own questions now. The principal legislation would have a broad definition of the relationship. An employee or a worker is someone who has written, oral, implied contracts, manual, clerical, administrative. Do you think that is not enough to give that broad scope to bring in all these other forms? So whether you are a platform worker or you come in through a third-party fee-earning agency, as long as we can distill that relationship of providing services, do we really think that part of the Labor Act, I think should be Section 91, is really inadequate? But maybe you hold that thought till Q&A. It's just something I was thinking, because we have to amend for every situation. I'm not sure we will not wait till our own children's generation to talk about another amendment. But talking about what is patently inadequate, and now we'll turn to Mr. Akpabio. A 1974 law providing for penalties, wages. Of course, you read the Labor Act together with the National Minimum Wage Act, for instance, which I think the national minimum wage for now is 42,000, or is it 46? Which 30, 30,000, which cannot bag a bag of rice suddenly anymore. And it's very, very, it's alarming, I can say personally, When I was invited to come to Abuja, I almost had to weigh the option of whether to come by night bus. Whether to go by night bus or spend over 150,000 just to get to Abuja. And it gets you thinking, cost of living for employees, the average employee. Imagine someone who is on minimum wage, for instance, and he can't buy a bag of rice or even take a trip. Because I was speaking to someone the other day, and even this night bus I'm thinking of taking, some of them as high as 30,000 naira now. So, Neka, this is not to put you on the spot, but really, what can we do? You have rising inflation. Yes, we know it's a global problem, but how do you think employers can help or assist to not wait for another amendment of the Minimum Wage Act, but what are the things you think we can do from the employer's perspective to cushion some of the effects of the skyrocketing cost of living, both from an employer side and even maybe regulatory. I know the simple answer to regulatory is, okay, increase the minimum wage by fiat, by legislation. Of course, we know the one that has been increased. Not all the states are paying it anyway. So where does that leave us? What can the employers do to cushion the cost of living adjustment issues we have presently? That's for Mr. Fabio.
Again, yes. I would like to thank you for taking the wise decision of not going by night bus, because the cost of it, including banditry, kidnapping, versus the cost of the air ticket, I leave that to take that decision, which is more expensive. Yes, national minimum wage is 30,000, but it's time bound. And very soon, the discussions and negotiations will come up for the review of that. However, pending when that is done, for organizations that are in the unionized environment, you will agree with me that they have a structure which is called the collective bargaining mechanism, which is done sectorally, whether in the food and beverage, in the manufacturing, in the chemical, and on and on. Now, some of them are done yearly. I know that in some sectors like the maritime, shipping, oil and gas, while some are done every 2 years, while some are done every 3 years. Now, this also helps to shoot up the amount in terms of what is being paid. Please note that the minimum wage doesn't mean that that is what is being paid across the industry, especially in the private sector. Now, we did a survey where we went into all sectors and asked, what are you paying as a member company of NECA in your sectors? And what we discovered was that what they were paid was even higher than the national minimum wage of 30,000. So what that simply means is that 30,000 is the lowest, is the benchmark. So you shouldn't go below that, but you can go above that. I dare say, or I make bold to state, that there is no collective bargaining currently in Nigeria that goes below that. In fact, some of them are even far higher than that. So that you begin to know what is being paid across the industries. So minimum wage mechanism, collective bargaining mechanism across various sectors, even with sectoral unions and employers associations, and then even in the industry. When I say industry, plants, each individual company, there is something called the annual appraisal. And this is being done annually. Now we're at the end of the year. And then some of these appraisals are done either across the board, then in addition to it being done across the board, maybe 10 or 15% across the board, then there are some that are performance-based or target-based or bonus-based, also across for those that are merited or able to get it. That also adds to whatever they're taking. Then apart from that, I'm aware that there are also situations where people come to negotiate COLA, palliative. Oh, please, could you come up with a palliative just to cushion the effect of what is happening, and we call it COLA. So when those things are being put in place, the outcome of it is that the amount certainly shows off. Please note that I don't think any law can actually cure effectively issues of inflation or rising cost of living. Like you rightly said, it is a global thing, and on and on and on. Because if we're going to go by way of a law, I can tell you, if we go by way of the law, a whole lot of things will not be right. For instance, I don't know how much they're selling fuel in Abuja, but I know how much I got it in the filling station here in Lagos. And it's being touted that the amount might likely increase because of the landing cost and that which the marketers are going to give out to the final consumer. So the issue of a law, the issue of legislative, it shouldn't come in. It should be one of the issues of relationship, best practices, what has been ongoing within the industries across the board, so that is being implemented. Now, this gives rights, I'm sorry to state, this gives right to the fact that employers and employees need to make or place more demand on government. Because the factors that ages of inflation are not purely labor-based, they're economically based. And this issue of inflation or cost of living affect not just the employer, but the employees also. So while the employer is complaining, the employee is also complaining. Why? Because they both buy from the same market. And the issue of inflation or cost of rising will affect the purchasing power of both the employer and employee. So I just want us to take that and note those points so that we could factor it in, that employers are actually doing something which is an ongoing engagement. Thank you.
Thank you very much, sir. Thank you. Natalia.
Yes, thank you very much, Mr. Akpabio. So I'm taking this question to Mr. Esige. COVID-19 really opened up a lot and took our minds to, different things that we never knew could happen. Now, most workplaces are actually looking at the hybrid work arrangement. Now, the new trends of employees really are now beginning to consider this flexibility as one of the decent, one of the consideration really for a decent work. Now, my question to you is this: how can organizations like yours create opportunities for purpose-driven work and accommodate hybrid work environments to be more effective? Thank you.
Yeah, no, that's a very good one. I think that COVID-19, kind of forced a lot of organizations to move to, first of all, a more distributed model where everybody is working from home. Being a tech company, interestingly, we were already prepared to be all remote. And I can tell you we still have a very strong hybrid model where it's actually mostly remote for a lot of our engineers. A lot of the younger ones, they're not trying to come back to the office. And somebody even mentioned it, when you look at what your employees have to go through to get to work, where it's 3-4 hours, you also have to factor how that impacts your own productivity. And so we were able to make decisions to continue to keep, our team members, and we were prepared for it. In fact, we continue to see very strong performance with everybody at home. And one of the things is you need to make sure that you have measures in place for a collaborative work environment. You have, platforms for communication. Your cybersecurity is in place where you have your company internal boundaries where employees can log in for information or log in to collaborate on work. So that's one of the things. Now, speaking to taking it into a purpose-driven work environment, we really relate that, to our team members really having ownership and understanding of the reason they are doing their work. And that's really related to making sure that that collaborative environment, that's number one, and making sure that they have proper training and line of sight between the company's goals, what we want to achieve, and the activities that they have every day. And you do that, first of all, through multiple ways. Number one, and someone alluded to this, having happy employees or people who are who are not, having to think about, the hardships outside. So this is one of the reasons, for example, why the many in the private sector pay much higher than the minimum wage. The other way is, you make sure that they have the tools, technically in a collaborative environment, to be able to work together and have the training to understand. You provide a safe environment with proper verification, so that people who are not in their environment or, distractions, causing problems in their environment, are not there as well, which we all do very successfully. So these are some of the ways, you continue to, kind of work with your employees so that they have that purpose-driven work environment. And it's really, technology is at the center of it. It almost cannot be done without technology, particularly when you're talking about team members understanding their KPIs. A lot of times these days, you're measuring these KPIs using technology. And the technology is not going to be able to measure those KPIs if you're not putting the data in a collaborative environment. And you're not going to be able to put the data in a collaborative environment if the people that are doing the work don't understand what type of data that they need to create as a condition of their work. So this is how everything is really related. And this is why they say people process things, right? In business, in terms of, you know, people process tools in business in terms of creating that collaborative work environment. Thank you.
Thank you very much. Jamil?
Yes, thanks, Natalia. So, I mean, all we've been talking about so far this morning has been about the need to review the Labor Act to accommodate all these modern day realities. But I think recently someone pointed out a very germane point, which is that perhaps we are not making the best use of what we have already. So amendment is good, but even in the best of jurisdictions, amendments don't come every year. I have written a book on the subject matter area, and within 2 years, you see how almost totally outdated everything in that book is. So that tells you that even in the best of situations, legislation may not be able to keep up with development. But the regulators have a role to play, and perhaps more leverage than they are using. So if you look at some sectors, maybe the oil and gas sector, for instance, yes, maybe the Ministry of Labor is beginning to do more of that. You see that the Labor Act gives the powers to the ministry, especially, to issue guidelines on so many things. So, Ogona, do you think we are making enough use of that leeway, which is, for want of a better expression, making new laws by way of guidelines that will take into account emerging issues? Recently, we had guidelines issued by the ministry for outsourcing issues in banking and other financial institutions. I think there's one that has been issued on outsourcing in the oil and gas industry. We've had, I think, maybe in insurance companies too. So do you think that is more of what we should be seeing rather than being fixated on we must amend the Labor Act to make progress? What's your view?
Jamil, I totally agree that in the absence of an amendment, which clearly has taken ages, you know, we should explore that, if you will, a stopgap alternative of using guidelines and regulations. The problem, of course, is that an amendment is the ideal situation because creative lawyers will always find a way to question the validity of, you know, guidelines or regulations that may be issued at any point. For instance, Section 88, 1E and G of the Labor Act is what gives the minister those broad powers to issue regulations. The challenge that experienced and creative lawyers would put forward is that if you look at the language of that provision, it says that it allows the minister to make regulations to prescribe anything which is to be prescribed under the Act, but is not otherwise prescribed, or containing ancillary or procedural provisions that he considers necessary to facilitate the operation of the Act. The problem is that if the focal position of the Act is to regulate unskilled workers, and you have a few provisions that apply to sorry for the break in transmission. So an argument can be made that you can't then make regulations that will draw away from the focal operation of the Act. This is just, you know, theoretical. I'm not saying it's been canvassed anywhere. But I'm saying that in challenging the validity of guidelines, this is just making the point that the ideal situation is to amend However, we can rely on those guidelines provided that it can be shown objectively that those guidelines do not fly in the face of the purport and intent of the Act. Some people can argue that the Act really serves to regulate unskilled employees. So if you don't issue guidelines that then relate to people we can refer or classify as skilled employees, people who exercise, administrative, management, technical functions, you might then have a problem. But I completely agree that we need to look at that more. And as you said, in recent times, there's been a push to do that. I think the guidelines for contract staffing in the oil and gas industry was issued as far back as either 2011 or 2014, I'm not sure now. But in recent, 2015, but in recent times, we've also seen, as recently as September 2022, the guidelines were issued to regulate, contract outsourcing, contract staffing in the banking, insurance, and financial sectors. In fact, just a few minutes to even highlight that particular guideline. The class of employees that guideline refers to are some of the most, that class is one of the most abused class of employees. For such a long time, contract staff have been used, just fire at will. There is no path to career development. There is no increment in salary. You just exist at the pleasure, of the employer. In fact, when it got inconvenient for the employer to even hire them directly, you just go to labor brokers and just have them bring them in. Whenever you feel like you terminate the underlying contract and move on with your life. But the benefits of guidelines and regulations can actually be seen in the provisions of this guideline that was issued on the 8th of September 2022. Among other things, the guideline provides for entry requirements. It provides for minimum pay. In fact, if you look at the provision on minimum pay, it says that there has to be an annual increment on salary, which would of course help alleviate some of the issues that we face today from inflation. It also talks about the fact that there should be opportunities for career advancement within 2 years, but not later than 3 years. It talks about career path and development. Very important, the opportunity to be assimilated, to move from that non-permanent position to a permanent position, of course, depending on the recruiting standards and processes of the employer. It talks about unionization, which is important because, as was mentioned earlier, if you have a collective bargaining agreement that these people can partake of, it then helps deal with some of those exploitative practices that we usually see. So, in fact, the guidelines actually guarantees the right to unionization, and then specifically mentions the unions that that class of employees can belong to, as appropriate. Of course, there's collective bargaining, there's disciplinary procedure. For the most part, if you look at some of the cases relating to contract staff, you find that particularly in banks, you find that once there's an issue, money has been lost somewhere, immediately the next day you're off. There's no, because you're not regarded as a permanent employee, there's no established process to ensure that you're heard fairly. The guidelines takes care of that, ensures that you're entitled to fair hearing, you're entitled to fair representation, you're even allowed to attend some of those disciplinary proceedings with somebody who can represent or canvass your position. So the point is, looking at these particular guidelines, which affects a very underserved class of employees, we see the benefits that we can derive. Yes, there might be issues relating to validity, which can be dealt with by the courts when they arise, but we see benefits that clearly, come into play when these guidelines are put in place. Of course, they're the more controversial ones. For instance, the one on the release of employees in the oil and gas industry, which many of us, find to be, at least employers of labor will find it to be tedious in dealing with their employees. But that's why we have the National Industrial Court. The court can deal with, considering the validity or otherwise of those guidelines. But to be honest, that's probably the best way to go in the absence of an actual amendment of the Labor Act.
Thank you very much, Ugonna, for taking some time on that. And again, it's good that we have colleagues from the Ministry of Labor because I think there's also a balance issue here. When you look at, or when I look at the new raft of guidelines that have come in, I think the point had been made to say, okay, is this not more of a restatement of the law, and you still leave quite a whole lot of issues left to, as we say, where both parties agree or subject to what? So are you really prescribing or just highlighting the fact that you can both come to agree? So I'm looking at that and balancing it with the one you mentioned from the old DPR, which is you will do this, this is how you will do it. And on the other side, one that is saying, okay, yes, they should have the right to unionize, they should have right to permanency, minimum pay, but let it be based on mutual agreement and all of that. And you wonder, okay, so what's the thought process behind this? Do you want to cause a change, or do you want to remind people of what they should be doing? You know. So, but I guess we'll be happy to have someone from the ministry also throw light on that, maybe when we get into Q&A. But let's move on to a few more questions, and then we'll do Q&A. For those who are online, you can drop your questions in the chat box, and we'll endeavor to take as many questions as we can from online and from the room at the end of the day. So Natalia, next question.
Thank you, Jamil. So my next question is actually going to Emmanuel. But before I ask this question, I want to just mention something, because this area happens to be related to family, really. And one of the things the Labour Act has been criticized for is being gender biased and focusing more on the women. I'm talking about maternity leave. And my chair also has written extensively on that. So I would ask that everyone who is here today and also watching from online to equally go and read that article. So now, there's been a lot of buzz-goes, really. And this is coming from the men saying that it's unfair that women are given the opportunity to go on maternity leave, and the men who labor to make sure that this baby is, doesn't get to have a leave to rest from all the stress. But I also wonder really what they do when they say they are actually clamoring for paternity leave. You find some of them on Netflix watching football, arguing about Arsenal and Man U. Anyway, so my question is, in terms of family rights, it appears the Labour Act makes provision only for maternity leave. With modern forms of parental leave, including paternity leave now granted by some states like Lagos State, and recognition of parental leave for same-gender parents and parents by non-vaginal birth, what reforms do you think are required in the Labour Act to bring it to tune with modern realities? Thank you.
Thank you very much, Natalia. So let me start from the same-gender issue. So we can just trash that out and then move on. So, of course, you know that by Section 214 of the Criminal Code and 284 of the Penal Code, homosexual activities are outlawed. And, of course, you know that the Same-Sex Marriage Prohibition Act of 2014 also criminalizes same-sex marriage. So, that's... we can just, but of course, there's still a larger picture to it, because we then begin to ask ourselves if there is maybe an international best practice on the point, and the quick answer I'll give to that is no, because as it is, there is really no consensus on the subject of sexual minority rights amongst the Committee of Nations. You don't really have sexual minority rights in the realm of customary international law, or even use cogens norms that you can say are non-derogable. We don't have them there. So we really cannot, push the labor or our labor laws into a position where they begin to offend, what we think might be our moral values. Especially, of course, if you're following the World Cup, you'd see what's happening with, of course, you know what I mean. So, but I sincerely don't think we can push it to that extent. So I think same gender, well, as far as I know, in Africa, for instance, it's really just the South African Constitution, I think in Article 9, that allows or that proscribes discrimination on the ground of sexual orientation. You don't have that in Nigeria, you don't have that in Northern Africa, you don't have that in quite a number of other countries, so we are in that situation where it would now almost seem that those kinds of discriminations are permitted, if I may use the word loosely. But so we can just take out the same gender aspect of it, and then we can now focus on paternity. Well, so parental leave, the focus of parental leave is really not the man, not the woman, it's really the child. Everything is really done for the interest of the child. Of course, we know that for the woman, yes, she has to recuperate and all of that. But for parental leave, you have a situation where the man also needs to be in the life of that child at the earliest stage, of development. So, parental leave is really welcome. But from an ILO perspective, you'd find that there's really no ILO convention currently speaking to paternity leave, even though you have about 3 of them speaking to maternity leave. Even in the world generally, of the 167 nations, you probably just have about 76 dealing with paternity leave, and out of which 29 African states also have legislations dealing with paternity leave. In Nigeria, we do not have, and I don't see why, we should really say the Labour Act is gender specific on this point, because, I mean, this is now legislation supporting women, and it's not, the other way around, But we have currently a circular that was issued. Of course, we know that the public service rules, the federal government now has 14 days given to men for paternity leave. And then there was a circular that was issued on the 25th of November, just last month, to clarify that those 14 days really mean working days, And of course, that circular also takes care of adopted children, unfortunately, I wouldn't know why, but it talks about male, okay, maybe because it was dealing with paternity, but it talks about male officers who have adopted children being also entitled to paternity leave, just like the counterparts whose children might have been born through vaginal birth. But unfortunately, the Labour Act even, really just speaks about pregnant women. It really doesn't address a woman who has adopted a child, or a woman who now has a child being a product of surrogacy. Nothing in the Labour Act speaks to that. So you just have a situation where it's pregnant women, and then you have some states like Lagos, and I think Enugu State, who have in their public service rules and provisions for paternity leave. So more has to be done from the Labour Act perspective. Of course, this is not one of those times when we can use the Labour Act as it is, because I feel it almost sounds from the way you ask the question that women are not happy that they are the only ones mentioned as needing maternity leave.
No. I said the men actually are protesting. Why the women are the only ones?
Okay.
Yes.
Okay. Well, so, but I mean, it's a forward-thinking thing for, the federal government through the Federal Executive Council to have brought in, the issue of paternity leave. Very okay, and I think that the Labour Act also needs to be amended, to take care of this particular reality. But I mean, even if you want to go to the issue of international best practice, I'm yet to find any of the ILO conventions that speak to the issue of paternity leave. So, but the Labour Act definitely has to be amended to bring in that reality. Thank you.
Thank you very much.
You can always expect a discussion on time off to be lengthy. So I think we have just barely enough time to take questions now. And we're going to be taking questions first from the room, and then we'll look online to see if we have questions online. So by order of precedence, the Leonard Silk, Mr. Roland Otaro, SAN.
Leonard, Senior Advocate of Nigeria in the house. My very good friend, Kuti, Senior Advocate of Nigeria. Afolabi, I know that is your surname. Moderators and panelists. Mr. Kwabio mentioned one thing, that the Labour Act of 1974 is archaic and there must be a touch amendment. I don't think so. The Labour Act of 1974 is now Labour Act 2010. And I want to say without any equivocation that it is not the laws they are in, the provisions, it is the implementation. In every country, once those in charge implements what is on ground, so be it. It is not the number of provisions or the quantity of the volumes of any law that makes it effective or accessible, but the implementation. In 1974, when the Labour Act was enacted, it was thereafter we had the Udoji Award. I was in 4-5 in secondary school then, so I knew what was Udoji Award. Even though I did not benefit. Thereafter, when I was teaching in secondary school, I benefited from Udoji Award. So what I'm trying to say is that it is the implementation. And everybody was happy in the country. There was money. You know, during the time of General Yakubu Gowon, everybody was happy. Even those in the military, oh, they had a fee day. But you discover that even apart from the Labour Act, we have the Employees Compensation Act. We have the Factory Act. And all these laws, whether Labour Act, Employees Compensation Act, the Factory Act, encapsulates the Maslow law of hierarchy of needs. That is what we need in this country. The Maslow's hierarchy of needs. Once our laws are able to encapsulate the hierarchy of needs, a lot of us will be enjoying, both the private and the public sector. Like for instance, in advanced countries, they respect workers very well. And workers, they know their rights because these laws are usually implemented. So I think this committee should look into the Maslow's law of hierarchy of needs so that these needs can be embedded, are not yet there in our statute books, can be embedded in them. Like for instance, in advanced countries, you have a social security card and the rest of them, or social security number. During the COVID-19 pandemic, a lot of workers, even those unemployed, they were given stipend, they were paid. But it didn't happen in Nigeria, except that those palliatives that were meant for the common people, they were hidden away, even by some state governments, and given to their relatives. I think we must have to look inwards, go to the drawing board, so that we will look to our laws, areas that we have a lot of lacuna or nakune, so that we can address this issue. Because workers are very, very important in every society. In fact, credence is not given to workers. And that is an aspect. That is a sector that must be highly addressed. Because one of the hierarchy of needs of Maslow was that, social security, safety, physiological, esteem, and self-actualization. But how many employers do that? Both the federal government and the rest of them. I don't want to go to the nitty-gritty of the problem with federal government and ASU. Because if the government is serious, you should not, the government should have allowed that problem to linger on, even up to now, because of our children in the universities. And that is where there is loss of esteemed value for our workers. Thank you so very much.
Thank you very much, Leonard, for your intervention. So, Mr. Osokweko, Chairman of the committee.
Interestingly, I was going to ask a question until my Leonard Otaru and PhD spoke. And I think I would rather respond to some of the issues he raised. He raised the issue about the problem not being the law, but the implementation. Right. To an extent, I agree with him, but to a very limited extent. Last month, we had the first sectoral bar bench interaction. And Leonard, I'm very grateful you were there as well, and we thank you for being there, and it was an interesting conversation. But on that day, I gave an analogy of a personal experience between me and my daughter. And I'll just permit me to repeat that story. We sat on the lunch table on this bright Sunday, and lunch was served. And my daughter proceeded to eat her meat before eating her food. My wife lost it and said to her, "At this way, would you stop that? Why are you eating your meat before your rice?" And my daughter turned to my wife and said to her, "Mama, it's my meat. Why can't I eat it when I want to eat it?" Now, I'm caught in the middle. This is my first daughter and this is my wife, who I love both dearly. And she asked me, who said, "Did you hear what your daughter said?" I thought deeply, and how do I handle this conflict resolution? And I said to her, "Sweetheart, I think she deserves an answer. Don't you think so?" And she was like, "What do you?" I said, "Okay, can we go upstairs and talk about this?" So we went upstairs, and I said to her, my daughter's statement actually got me thinking. We were not allowed to eat meat as a form of delayed gratification. But the means of delayed gratification now has changed. We can't use the solution to a problem that was there then to solve a distinct problem now. So, in as much as I think implementation is a problem, the dilemma we face today is totally different from the dilemma that was faced by the Labour Act that was implemented or enacted in 1974. The issues are a myriad and they are different. They are peculiar to our situation. And I think instead of even making new laws, I've always insisted, and I've written about this, that the powers of the minister under Section 86 of the Labour Act to make regulations is enough to simulate change in the employment law space. So really, the problem we face today are not the same as was faced in the 70s. And the solution to solving those problems are not the same solutions that solved the problems of 1970, even if they were the same problems. So we need to think about it and see how we can actually use those regulations to solve some of these problems. I think I'll stop here now. Thank you very much.
Okay. Leonard Silk, you wanted to say something?
Yes, I just want to, well, he has spoken well. I am not saying that the law cannot be amended or regulation. It is the same law that gives the power to the minister to make any regulation. But what I'm saying is that even though regulations are made, I am saying that we should, the implementation is what really matters. I am not saying that the problems of 1974, they are still the problems of today. But the laws that were enacted in the Labour Act of 1974 can, to a larger extent, solve the issues now by enforcement and implementation. In fact, when we get to my section on international best practices, we bring out some of these salient issues. Thank you so very much.
Thank you very much.
Well, except to add, I have a great insight today. Let me just lean on what Dr. Sarah said. I think the position really is not so much, I confirm that it's not so much about making law. It's the will to implement what's be there. And in many of the situations, I'll say, it's not so much about the problems of the past being separate and distinct from what we are. And I'll give an example. When Uguna spoke, he addressed the issue of the Labour Act and the raging debate for a long time that, look, it relates to just a particular sector, class of workers, and that doesn't apply to those in the executive managerial position. But that's not correct. If you bother to read Section 91, there is no distinction between whether you are an executive worker or a manager. That's Section 91 was made in 1974. So that Labor Act, please go back and read Labor Act, Section 91. There's no distinction whether you're executive, whether you're a manager, whether you're a cleaner. So, comes back, and we're still dealing with, we need a law to explain which law deals with this class of workers are supposed to do. 91 should be distinguished to say. But going forward, and I think it's important to also emphasize this. Minister can make regulations. Minister cannot make regulations to deal with what he doesn't have the power to. So there's a need to, not necessarily to reenact the law. There's a need to look at some areas that are not in tune with the social realities, no doubt about that. Maybe a review, but not so much about revising the whole law. That's my take. Thank you.
Thank you, Leonard Silk. I guess it's okay. There's, I'll get to you, madam. But let's take one question online, so that we are seen to be inclusive of those who've joined us virtually. And thankfully, Leonard Silk, Mr. Folabi Kuti, SAN, has answered some of the questions this person online was asking. This is from Chinedu Udu Akundu, and she had raised issues with regards to who is protected, why is it only government workers that are protected and all that, but you've answered that question. Thank you. The only lone question I think has not been addressed on this panel is this question on wages. And this person is asking whether it wouldn't be effective for the country's labor law administration to shift from monthly wages to wages per hour. You know, we have that in the US. I don't know whether anyone does it in Nigeria. I will ask Mr. Akpabio, as the employer on the representative of the employers on this panel, to answer this question. Do you think we'll gain any benefit from moving from monthly wages to emphasizing wages per hour? Does that optimize efficiency? Is Mr. Akpabio still with us?
He's trying to make. Can you hear me?
Yes, sir.
Okay. I see the point the person is trying to make. Fair points, okay? Fair points. But we need to note the issue of, like the learners say, we'll talk about the implementation and how workable that is going to be done. Yes, we're having judgments of the NIC that, well, when the employer tells you, okay, in the middle of the month, okay, goodbye, then the employer will need to pay for the rest of the days in the month. Fair point. We're having issues where you could prorate. Fair point. But what happens to what effect would that augur well on the employer? Now, you are in chambers, you are in practice, and you have paid your junior for 1 week work, and the next week, you have a matter problem in the Court of Appeal, and the person says, sorry, sir, I will not go except you upgrade my payment from X amount to Y amount. Now, what happens? You now start all over negotiating. Meanwhile, you ought to have been preparing for the matter, probably at the Court of Appeal. How would that all go well? How would that all go well? So we need to look at it critically. Yes, we are beginning to have a couple of things like flexible working hours in Nigeria, and all of those flexible working hours are bringing on some of these international practices, but we need to be able to distinguish between the environments over there and the climate that we are operating here in moving forward. So I will still want to submit, with due respect, that though is a fair point, but there are a couple of issues that we need to tinker with in terms of it being finalized.
Thank you very much, sir. And the last question from the back of the room. If you could please introduce yourself, madam, and then ask a question.
My name is Chizoba Mojeku, human resources practitioner. So in talking about the law, my understanding is that every law is situated in a bias. So it's usually around the time that the law was written with the circumstances that had been seen. Nobody looks forward into 10 years, 15 years, 20 years, 50 years, you know, as we're doing the law. And then also in the interpretation of the law, we all interpret it based on our exposure and also in terms of our biases. And so we need to take that into consideration, and I'm going to put it out there to you. The second one is, if you look at the future of work, so the future of work is about, you know, the nature of work is changing, there's rapid automation, we're widening the net in terms of who's a worker in the workplace, and they may not essentially be your full-time employee. So the nature and the definition of employees is changing as well. And then if you look at the one that's been most disrupted is the workplace. And so home is work. So where does the law sit in terms of things like accident, workplace accidents, where the home noun is the workplace, who provides, you know, the ergonomic chairs or the facilities, you know, or the equipment, you know, for the workers. So these are some of the things that we also need to take into consideration. And then also factor in the rapid acceleration of resentment, you know, by the generations, the younger generations against authority and power. And so, you know, where as employers and where does the law stand, you know, and how do we look forward 20 years, we're only just talking about what's going on. We called it the future of work, but it's really the future, the noun of work. But look 10 years, 15, 20 years. What are those things that we're seeing that we think are going to accelerate, and how do we, will the law catch up with some of the things? An example is I joined Guinness in 1990, and I was their first female brewer. Then the question was, could I run shift? Could I run shift as a woman? I did run the shift as a woman because the argument was that I was in a management position. But the law is not very explicit about that. You know, it says that, you know, women should not run those night shifts. And so you begin to see... So these are some of the issues. There were many things that were not envisioned.
the introductory remarks, and the first panel, very educative. We will now be starting up with the second panel, which I'm sure most of us are here for, particularly employers of labor. As we're looking at the issue of the great resignation, or great opportunity, issues are rising. So how are we treating this whole wave of JACPA, migration, employees hopping from one workplace to the other? What are the options open to the employers to ensure continued operations that are able to deliver to their clients, and that the company doesn't go under because there isn't any employees left? To moderate this panel is Chinwe. Uh-oh. I see that. Yeah, okay, we're back online now. No, it's the second panel. Please, could you move your slide to the second panel? This is the first panel, please. Well, moderating this panel is Chinwe Odiwewu. She's the former legal director of Guinness, Nigeria. Sorry, she's the current legal director of Guinness, Nigeria.
Former.
Hi, Chinwe. Don't mind me.
Good
My apologies.
afternoon.
Good afternoon. And then we have Chukwubike Onwuzurumba, who's a partner at Oak Legal. Chinwe is joining us virtually. That's her. And Chukwubike is here. Onwuzurumba, Chukwubike, where are you? Okay, your panel starts now, so you do want to come. Chinwe, so I would leave you to introduce your co-panelists. That works for you?
Yes, thank you. I think this is Mary, right?
Yeah, this is Mary, yes.
Okay, hi, Mary.
Hi.
Yes, so Chibike and I will work together,
yeah.
You know, hoping that
fantastic. Chibike is here.
Will work.
So,
thank you.
All right. So let me say a few words about our moderators. So Chinwe Odiwewu is a legal practitioner, a mediator, a mediation advocate also. So she's always encouraging us to mediate as opposed to go to court. UK, and certified trainer in mediation and negotiation of the Bond University, Australia. Chinwe is also a member of the panel of neutrals of the Lagos Court of Arbitration, the panel of neutrals and training faculty of the Lagos Court of the faculty of the Lagos Multi-Door Courthouse, training faculty of the Negotiation and Conflict Management Group, and the Standing Conference of Mediation Advocates UK. She was until recently the legal director of a top multinational, and currently, as I was duly corrected, the legal director of Guinness. And she will, she's well, prior to all of these moves in-house, right, she was in practice like most of us. And so you're very much in safe hands with Chinwe. And her co-moderator, Chibike Onwuzurumba Neto, is a partner with Oak Legal, and he has experience with a particular focus on dispute management, project development, and public sector management. He represents a client base that includes private equity firms, multinational EPC companies, upstream, downstream oil and gas operators, financing syndicates and regulators, and has worked on electronic power transactions, both greenfield and brownfield. In Africa, exceeding 6,500 megawatts in capacity, and $1 billion in deal size. His clients include major commercial, local and multinational companies. He started his professional career as a Pupil State Counsel with the federal government ministry, and has since moved on, of course, as we see, to private practice and advising over these issues. Of course, his background in labor, in dispute resolution, means he's well versed in labor and employment issues. And so, Chinwe, would you be introducing your panelists? You have some very distinguished. At the very least, I will mention them, and then I suppose you will do the honors. So first on the list is Chizoba, Mrs. who provided some very insightful comments. Yes. During the conversation about how the law shouldn't just be situated for the time, should be forward-looking, and that's actually something very important. Culture at Alukano Yebode, one of the leading commercial law firms in Nigeria, will be joining us virtually. And we also have Grace Omolama, Director of Human Resources, Nigerian Breweries PLC. She's been the head since October 2017. So a few words about panelists. Chizoba Mojeku is an experienced board-level HR and learning lead with extensive experience in organization development, change management, and human resources transformation. With over 25 years experience, she has worked across multiple industries and led several management engagements geared at transforming HR functions and improving HR service delivery from HR process designs to HR management system implementation. She's currently team lead at the GIZ ECOWAS OD and Governance Project for the GFA Consulting Group, GmbH. And in this role, she serves as the HR expert, driving capacity building towards the EU pillar assessment for direct funding of ECOWAS, as well as operationalizing the newly created centralized ECOWAS Learning Center. Prior to this role, she served as lead consultant at Deft Adroit Consulting and as a director, capacity development at the Central Bank of Nigeria. She has also served as a HR director at the ECOWAS Commission and held positions at MTN Group Management Services, MTN Nigeria, Accenture, and Guinness Nigeria. She holds credentials of Global Professional in Human Resources, GPHR, issued by the HR Certification Institute, and is a senior certified professional from the Society of Human Resources Management. She volunteers as a member, Public Policy and Advocacy Committee, Public Policy and Advocacy Committee at the Chartered Institute of Personnel Management of Nigeria, CIPM. Ladies and gentlemen, please do me welcome Mrs. Chizoba Mojeku. I should mention that we may have Mr. Yemi Fashion who join us. He's also a panelist on this session, and he's the founder of the YF Network and YF Academy. There appears to be conflicts and scheduling with him, and if he's able to, he will dial in and join us. Mr. Fashion has over 30 years experience that cuts across major sectors with proven track record in executing strategic change, management initiatives, HR service delivery, organization design and development, and HR transformation during mergers and acquisition. He began his career with a background in English from the prestigious Obafemi Awolowo University, and later proceeded to acquire an MBA and certifications from Cranfield University, UK, Lagos Business School, and several other institutions. He's a highly respected thought leader and subject matter expert on HR strategy, manpower planning and resourcing, performance management systems, succession plan, management, organization design, as well as cultural and leadership transformation. Some of his clients include KPMG Professional Services, Standard Chartered Bank, Stanbic, FBN, Quest, and Global. We do hope he's able to join us. Tayo Asa, People and Culture, at Alukanoyebo, referred to as Tio. Transformational leader, years of experience in human resources, management, and leadership development. His life mission is to help others discover, develop, and deploy their leadership potential for lasting impact. He has worked across Nigeria, Ghana, Gambia, Liberia, Senegal, Kenya, and South Africa, so he has quite a bit of experience in the African continent. We work collaborations across Europe, Middle East, and North America, in addition to his multi-industry experience in consulting, telecoms, financial services, healthcare, non-profit, and oil and gas. Having led HR teams at Alukanoyebo, Africa's leading Tier 1 legal services firm, he is the current head of people and culture there, as I did mention. So do make me welcome Tayo Patayo. Thank you, Tayo, for joining us. The final panelist, Nigerian Breweries PLC. She's a seasoned business and human resources leader with experience spanning 3 decades. She honed her skills working in international and multicultural organizations where she has championed notable corporate transformational projects across the African continent. Prior to her current role as a Human Resources Director at the Nigerian Breweries PLC, she was a Director of Human Resources for Nigerian Bottling Company, a member of the Coca-Cola Hellenic Group. Prior to that, she had senior roles Tell Africa. Thank you. She has both broad and deep experience against various domains within HR, including leadership experience, organizational transformation, change management, process improvement, talent management, culture, diversity, equity, and inclusion. Do welcome with me Grace Omolanai, and I leave you now in the hands of your moderators. Thank you.
Okay, hi. Thank you, Mary. Hello, everyone. So this is the real hybrid session. Okay. I didn't hear hand claps from the audience when we're introducing everyone. So maybe we should pause until we hear a round of applause from the audience. I can't hear you. Louder, please. Don't mind me. It's not for me. It's for the panelists. Chibike, thank you for clapping. And Chizoba. Okay, Tayo, we need your video on. It's great to be here. I'm happy to be co-moderating this session with Chibike, who is there with you. I hope you can all hear me clearly. And we pray, one of the prayer points for this post-COVID era is to make sure our networks do not fail us when we're on Zoom. Okay, so welcome to this session captioned Great Resignation or Great Opportunity, Issues Arising. Many thanks to the SBL EIR committee for inviting me to do this. And I'm happy to be here with all the panelists. So interesting points. I just discovered that Chizoba and I are both ex-Guinness. Grace and I are both ex-Nigerian Bottling Company. Tayo, I used to work in Bawa and Igibalo, and you work with one of our major competitors, Alukanoyebo. So, Chibike, no story for you yet. Okay, so just an introductory statement. As we know, there's been a lot said about the Great Resignation. So a simple definition I found online on thestreet.com is that the Great Resignation refers to the higher than usual number of employees voluntarily leaving their jobs since late 2020 and 2021. Although resignation data shows that this phenomenon actually began more than a decade earlier. So I think the noise became louder after COVID, but it looks like this has been happening. So people have been resigning for different reasons. So happy to have our panelists with us, Grace Omolamai, Chizoba Mojeku, Tayo Opatayo. Like Mary said earlier, Yemi Fashion says he may join us at some point, but if he doesn't, I know that Grace, Chizoba, and Tayo will do justice to the topic. Okay, so Chibike, over to you to start the question.
Yeah, thank you very much, Chinwe, and thank you so much for making this very smooth. We were all a bit concerned when we realized that half of the panel and half of the moderators were going to be in different locations. But Chinwe, you've been very fantastic in getting this very off and very smoothly. So thank you for that. And again, we're happy, Chinwe and I, to be moderating this particular panel because we've got panelists who offer more than just a specific industry experience. So even though this is an Nba-Sbl event, we are hoping that the insights we give you here are not going to be just specific to the legal industry or the professional services industry, but a much wider scope than that. And thankfully, our panelists are persons who have been all over as far as industry variety is concerned, and who have also seen it all as far as HR and labor issues are concerned. So again, thanks and welcome everyone. We hope you have a very insightful session. And I would like to start off with, having the panelists give us their general thoughts on the Great Resignation, the Great Japa, as some people have called it. What does that mean to you? And both in terms of your experience and generally from being an industry player. So I think I'll start with Chizoba, just because she happens to be right here with me. Please tell us, what do you think about the Great Resignation?
Chibike, I'm not going to look like I'm pushing this a bit, but I think I would like to hear Grace and Taya, who are actively managing people and living with that experience, because I do have, I'm known in the industry for contrary opinions. So I do not want to start with an opinion that is not entirely grounded, from experience of having to deal with an organization where people are leaving. So it will help if Grace and Taya start, and then I can then now, support and probably provide a different perspective.
There you have it, the Great Resignation right here in front of you, gentlemen. So I think let's go with you, Tayo. If you're right there. Tayo, please.
Okay, good afternoon, everybody. First of all, I want to apologize that I'm in transit. Reason I couldn't make physically to Abuja, but I'm excited to be here and glad to see every co-panelist, to see, as I call them, my elder sisters, Chizoba, who is also my mentor, Grace, Sis, and of course, my senior colleague and also one of my advisors, Yemi Passion. So it's exciting that Nba-Sbl has been able to put together such amazing experts in the field with also diverse and rich experience. So when we think about the Great Resignation, right? So I consider it from 4 dimensions, right? Context, right? So we look at it for the national level, the organizational level, the team or peer level, and then we look at it from the personal level. Okay, and what is important for organizations is to begin to ask themselves if this Great Resignation is something that as well applied to the long term. So when I say the long term, it will apply to the next 1 to 5 years, or if it's something that would be just short term and maybe in the next 1 to 2 years, we're going to see a winding down from being at the forefront of engaging our talents that are in quote jackpying and then relocating or transiting every day, and also with breadth of experience across different industries. I know that we might be in for a long haul of seeing, a movement and a talent mobility from Nigeria to other parts of the world. What this then tells us is the fact that we need to ask ourselves that from the bottom up and top to the bottom, how do we address this reality? Okay? And also ask ourselves, is it really a brain drain, or is it really also, are we exporting talent? Should we look at it as exporting talent, or that we are being drained of talent? And how can we then leverage that? From an organization perspective, it's important to note that there are some things that we can't control. So that's why I started from the context of the national dimension to it. To some extent, some other clients are a bit more developed and provide some kind of livelihood, right? That living and working here, we are still journeying achieve. That's number one. Number two is also that even industry and organizational wide, right? There are expectations that many of our industries here and our organizations are not yet meeting in the context of job enrichment or career possibility that other clients, right, provide. Then in the context of looking at peers, people, whether we like it or not, our talents compare themselves with others. Which in the two-edged sword can be detrimental when it becomes an unhealthy comparison, but it can be also motivating when that comparison is done from a point of what potential they feel they can unleash from what they have, and motivated by what their peers are doing. And so, with that context that I've established, the great resignation is ask ourselves for the next 1 to 4 or 5 years as we work for talent, and as we want to have the best people, the best and brightest working for our organization, is how do we reframe our thinking beyond this being seen as a resignation to seeing it as talent reassignation, right? So it begins to creep into our mindset that really, how do we get to be able to have the kind of level of engagement with talents that we could to them? Okay, so I'm sure that there will be more questions, one or two that will answer as regards the things that we can start looking at. But what I want to just leave in this open comment is that it's come to stay. We need to be able to look at the merit of it, and until we look at the merit of it as an organization, right, or as institutions or as agencies, before we can align or adapt, based on our own reality, to be able to tap from it. Whether we like it or not, if it's not the personal level that not the industry level, the national level, or it can be a combination of the affecting,
Right, Tayo, thank you very much. The last few seconds of it was a bit spotty, but we got it. Thank you. So, Grace, please.
Thank you. Good afternoon, everyone, and thank you indeed for this opportunity to be here. I'll stand on all existing protocols, and I'd like to just continue from where Tayo Patayo stopped. I do agree with him that it is important for us to look at the Great Resignation through those four lenses: at the national level, the organizational level, team and peer level, and the personal level. And I think I'm going to leave that national level to Chizoba to do it justice with. I'm just going to go into our organization so we can just look a bit at what people are living every day. So for the organizational level, I have a head of department who has spent time training people for 2 years. And then this individual now comes in as a first line manager in charge of brewing. And this head of department is depending on this first line manager to lead the team in the brew house or in the packaging line. And this individual that you've spent 2 years training, really giving core training in training school, accommodation, everything, and the person starts to work, and 6 months down the line, this individual drops a resignation letter because he or she is so talented, and so this individual has been snapped up and is going to Canada or to the UK to take on another job. And the head of department says, okay, that's fine, yeah, HR, please get us another person, or there's somebody else who will move into that position, and then the individual resigns. So for the organization, it's causing quite a strain. Why do I say that? For my organization, for example, from a low of 2% attrition rate averagely every year, this year alone, we are reaching a high of 5.8% attrition rate yet to date, and the year still has a few weeks to end. So you can imagine the nightmare for that head of department that has had his or her steady source of people coming in through the stream over the years, now facing this phenomenon. It's causing quite a strain, quite a stress for the individual. And with so many things to deliver, that brew is not going to be ready tomorrow. It will take at least 12 days. And depending on it, if it's Heineken, for example, it's going to take 28 days for the brew to come out and be ready to be packaged. So you would agree with me that there's a whole lineup of things that, that you can't just switch tomorrow. These individuals have to be there, they have to be trained, they have to go through certain processes before they are ready, as it were, to occupy certain jobs that they occupy. So when this great resignation comes at the speed at which it comes, it becomes a bit of a challenge for the organization. And for the team too, it means that teams are having to do more, so there's stress, so there's issues of work-life balance, there are issues of having time to do other things other than work. However, in all of this, we do see that it presents a great opportunity. And what is that opportunity? It presents an opportunity for organizations like ours that have been around for a long time, for 76 years this year, to begin to relook at how we operate and see how we can improve it, how we can ensure that the work environment is even better, is more open, because today now we know that people care about the kind of work that they do. It has to be meaningful work for them, but they also care about how they do that work, where they do the work, and when they do the work. So it presents a great opportunity for us to embrace this future of work that we've all been talking about over these past few months since the pandemic. We would agree that things are no longer in the traditional way that they used to be. So there's a new normal that's coming in, and all of us as employers of labor in the private sector, in the public sector, have to begin to rethink how we operate, the kind of framework or environments that we enable for individuals to work and to thrive. And I dare say that that is why we would have topics like reimagining the workplace being talked about right now, because these are topical issues. So it goes beyond people resigning. Yes, people in itself, the great resignation is not all bad, because some of these people that are going will come back home better equipped, better skilled, and we are the ones that are going to get the greater benefit. So how these people go, when they go, where they go, what is left behind when they go, is all important to the great decision that they're going to make tomorrow, whether they want to come back. And if they want to come back, will they be happy and willing to come back to you because you've had such a wonderful, loving relationship as employer-employee or not? So these things become very important, and they give us, people like me, the opportunity to rethink, redo things, make things better, make them different. And when I say better, better for the people, for the employee. Make it an environment that is safe, that is welcoming, that is caring, but at the same time daring as well. That gives them the opportunity to do meaningful work that inspires them. So without this pressure, let me put it that way, we would not think that way, we would not think differently. We'll still be doing same old things, same old way, where we think that yes, the employer calls the shots all the time. The employee is the one who is out there waiting to beg for a job. But the tables have turned. It's not exactly like that. There's a rebalancing that we see the Great Resignation bringing to bear, and it's a challenge for us. So I would see it as an opportunity, as a challenge for the employer, for the organization to show up and do better and do differently. Of course, live through the pain and the stress that comes along with it to see how you can, we can all redo things or do things differently better for the benefit of the nation at the end of the day. Thank you.
Right. Please, we're back to you.
Okay, thank you very much. Thank you very much. I'm glad that I allowed Tayo and Grace to speak, because they are the ones who are living, you know, with the everyday reality of people leaving the organization. Particularly for organizations like Nigerian breweries, where attrition is not as high as, you know, the financial services as well as the technology firms. Thank you very much for the opportunity to speak today. I come from a family of lawyers. Unfortunately, you know, that didn't, we were not infected, or the genes did not carry down to the next generation, and it's quite sad. But every single time I have an interaction with lawyers, I think about going back to school to go and study law again, you know, to just try and understand how their brains work. No, to go and do the law degree, there's no point in doing a PhD when I can go and argue my case in court. So for me, the Great Resignation, you could look at it from many different angles, and you ask yourself, why is it happening in Nigeria? The resignations that we're seeing now didn't start today. And if you look at the things that have happened in Nigeria in the last 10, 20, 25 years, even as more recently as in the last 5 years, you find that if we have been looking, we would have seen that we will have these issues. Think about Nigeria, average age 19.9 years. So we've got a very youthful population. But who's in charge? It's still our generation and the generation above us. And their voices, the voices of the young people, are not being heard. We're not integrating them into the governance, and we're also not providing opportunities for them, the kind of opportunities that we had. I graduated from school at 20. I had no clue what I wanted to do with my life. But there were all these adverts that were coming from Cadbury, Nigerian breweries, Guinness. I applied, I got interviewed, and I got hired. But can we say exactly the same? Is that the reality of our young people in Nigeria? That's not their reality. And then, because it's not their reality is also not the one that they can go out freely like you and I and come back freely. They can go out and may never return to their families. They may go out and the next time that they see the light of day, maybe 46 days or 3 months or 4 months after. Why? Because our security agencies has decided that this one looks like a 419 or has no business wearing dreadlocks, or how did you make your money? Why are you driving this kind of car? I got my first car at 22, but are they allowed to get those cars? Are they allowed to get the jobs? Are they allowed to have a good life? So these things have been brewing They have been brewing, and we have made Nigeria uncomfortable for young people. We have made Nigeria a land of no opportunity for young people. And so any little opportunity that they have, they will go away. Do you blame them? I don't blame them. But we can flip it and look at it like, I think it's Tayo that said we're exporting talent to other countries. You know, this talent is still our talent. This talent is still talent that we can woo back into the country. But are we willing to have that conversation? So on a daily basis, I keep hearing, oh, Jata, and then people will laugh about it. It's like the more difficulties that they find in their host countries, the happier we are in Nigeria. Okay, you left us to go, go and suffer in that place. But think about it. In terms of development of people, you could look at it, in terms of 4 E's. So there is exposure, there is education, there is experience, and then there is the environment. Or you could look at it at 4 T's. So there is training, there's travel, there's transfer, and I think there's teaming. So this is all about building experience and exposure for people, because these are people who are going to go and see where it works. And as they see where it works, think of, I think when it was President Obasanjo, we had a lot more people start coming back into the country. So look 15 years down the line, if we get our act right, our leadership right, then in the next 10 years, 15 years, 20 years, we may be able to re-attract these people back into the country. But for the national, think about every single time we have a dispute with professional bodies. And we never resolve those disputes with the professional bodies. So we had disputes with the resident doctors. We have with ASU. We have with all sorts of professionals. What we're telling them is, we don't need you. You will never get fairness and justice. So then why do I stay? When I'm not valued? Why do I stay when, nothing works? So each time we don't resolve disputes, and everything in Nigeria sits on fairness, justice, and equity. We don't get justice early. There is no fairness in the things that, and of course there is no equity. So until we realize that we are the ones, through our policies, through our posturing, pushing people out of this country, we will forever continue to worry about, people leaving. Is this going to end? No. We've let the dogs out. We can't leash it. And it's only good economic development, good strategies that are going to let people know that, yes, we're still back and open for business. And there are ways that we can utilize these people. From the organizations, we keep pushing things to the organization level. Yes, the organizations can make themselves attractive, but there's no attractiveness of an organization that is going to that's going to let a 24, 25-year-old who has opportunities to go out, either to go and do masters or to find a job in another place, to say that I'll stay in Nigeria. Nigeria, there is no doctor. Today, if you're ill, of course you won't get treated. We don't have the roads. Lagos is congested. We can't work from home. So there are just so many things. Rather than, talk about this, is for us to sit down. And the reason why we're not sitting down is that we are looking at things from our generation. And I like the story that Mr. Kweku told, about the delayed gratification being different. It's the same. We always approach conversations, those of us in our 50s and above, we approach conversations from our frame of reference. We are not listening to the young people. We're not hearing them. And we need to start hearing them across sectors, across everywhere. Government needs to engage and engage. I was talking to my friend in NECA, and I said the Ministry of Labor needs to engage. We need to have conversations upon conversations upon conversations and hear the voices of the people. That's the only way we can get to the root cause and then start putting in things for us to be able to make things happen. Thank you.
Wow.
Yeah,
the pressure is getting worse according to social media. But this is such an important topic. I mean, just listening to Tayo, Grace, and Chizoba, I mean, we can't overemphasize the importance of this topic. And I thank you all for your comments. And before we go to the next question. I just want to mention a few points made by Tayo, Grace, and Chizoba. And I mean, they said a lot. Tayo mentioned 4 lenses, which Grace also mentioned as well. And, Tayo talked about exporting talents and reassignment of talent as well. And then Grace, considered that, the Great Resignation is causing a strain on organizations. And, it's very clear that it's causing a strain on organizations. And she's talked about how, it's kind of good pressure, because without that pressure, perhaps organizations would have been a bit more relaxed about doing things. So it's the employees' market. Organizations need to step up with whatever they're doing regarding work culture and all that. And then Chizoba has come with a human rights activist cap. Maybe you should still study law, because honestly, you spoke like a real advocate. And you mentioned that beyond organizations, we shouldn't just be putting the pressure on organizations. We should look at the environment called Nigeria. I know you mentioned the 4 E's and the 4 T's, very interesting points. But beyond, the work culture and other things, making an organization attractive, organizations are situated in the country called Nigeria. So no matter how attractive, she says, no matter how attractive an organization is, you cannot stop a young person who has seen an opportunity abroad from, jackpot, like the term says, just because the organization is attractive. Why? We have to fix Nigeria. And of course, she's called on all the governments and all industry bodies that there must be an engagement. So there's a lot said, and I hope people are taking notes. I'm looking forward to seeing questions in the Q&A tab online, and I think Chibike will take the questions live. So let's go to the next question for all our all our panelists. It's really, really an interesting topic, and honestly, just listening to the 3 of you, it's it's getting clearer why we're having this conversation, and it was a very good one organized by SBL and EIR. So I saw something in an article by Forbes. So let me just read it. So it says the Great Resignation is a wake-up call for organizations and an opportunity to reevaluate their work culture. Business leaders must move away from a surface-level solution and strive for a cultural shift to retain their best employees and attract new talent. Grace mentioned a few things already in this regard, but I've picked out, I was trying to make a list, what are the reasons for resignation? The assumption when we're talking about Great Resignation is just a jackpot thing, where people are just leaving Nigeria. But there's a lot around the Great Resignation, and like it's been mentioned, it's not just recent, it's been happening. And Chizoba said if we had looked closely, we would have seen that 10 years ago, 20 years ago, things were already building up, and now this mass exodus. So people are leaving their jobs, not just to leave the country, but there's a whole long list. There's work culture, there could be issues with colleagues or line managers. There's a saying that people say they leave their bosses, not their jobs, actually. There are issues around maybe health, and now there's a lot of conversation around mental health. But of course, there's pay. People leave their jobs for better pay, and then, green pastures could be within Nigeria, outside Nigeria. So it's not just the jackpot thing. And then Grace mentioned that, when people leave and they come back, with better skills and all that, the country and organizations would, get the benefits in the long run. But Chizoba also mentioned that there are a lot of people that will leave and never come back. So there are 2 sides to this. So the question to everyone, and I think perhaps Grace can start, and then Tayo, and then Ijoma. The question is, from this statement I read out about Forbes, right? There are 3 intertwined issues: organizational culture, talent retention, then employee value proposition, which talks about talent attraction, And Grace, you've already shared some of your thoughts, but let's bring it, a bit more granular, in the sense that, what would you advise organizations? Because I think you've mentioned the things that you're doing in your organization, but let's really bring it home. If we were to make a list of things that organizations must focus on, what would they be, to ensure that we deal with the issues? So it's more like, how are organizations, dealing with this great resignation? What are the mitigants to put in place to avoid it? Because really, while we say there are benefits, I'm not sure it's something we should encourage. It's something we need to deal with. Thanks.
Absolutely, Chinwe. Thank you so much. I really liked what Chizoba said about the pressure that's been put on organizations to kind of fix it all. And a lot of times it can be very overwhelming. However, we have to start from somewhere. We have to create what I can call islands of excellence, so to speak. If all of these organizations can create islands of excellence, maybe that's going to now, widen the scope and then challenge the status quo, so to speak, and then nationally, we can see a movement that happens. Having said that, I would only speak from my own perspective on what we see as very important to do. There are several things that needs to be done, but I think one of the places to start is what is within your control, or what is within our control as organizations. What can we control as organizations? Oftentimes, we can't control the temperature of the climate in the organization. That is well within our control. We can also really control the culture of the organization. So those are things that are well within the control of every organization to manage. Whilst it may not stop altogether that individual from taking that opportunity outside because of the other factors that are outside of the organization's control, it would help others who are left behind delay the consideration to want to go. Or maybe decide that, okay, I'm not going to go. I think I'd rather stay here because I like it here. Yes? So for us, what have we been doing? And this did not just start today. We have been focusing really on building the culture, improving the climate within our organization. And why is that necessary? We believe that it is necessary for us to do that because people can only be successful when they feel safe in the environment. And by safety, I don't just mean physical safety. Of course, physical safety is very important in a manufacturing organization like ours. It is top-notch. We say safety first. If it is not safe, I will not do it, and I will stop others from doing it. So when we say that, embedded in that is the culture that enables an individual to stand up and say, you may be senior to me in hierarchy, but if you're doing an unsafe act, I should stop you and correct you without feeling afraid. So that brings me then to the other kind of safety, which is psychological safety in the workplace. How do we ensure or create an environment that is psychologically safe for our people? It becomes very important because then it speaks to the culture. How do we champion a we culture? And by a we culture, not us versus them. By a we culture, here we are holding everyone accountable for creating and nurturing a culture that is safe psychologically, a culture that is caring, and by caring, we don't necessarily mean that we're going to be permissive and permit all sorts of things, no. But it is both caring and daring, because then you care and then you dare to hold people accountable. And also a culture that is inclusive. Is it us versus them? Is it male versus female? Or is it him and her? Or he and she, as the case may be. So that is the kind of environment that we need to create. And that is the kind of environment that we are working every day to create. And so we encourage everyone to speak from the heart and to connect in an authentic way, and do not be afraid to be vulnerable. So we just don't say that, but what we have actually been doing over the years is to equip our people tangibly to be able to live these cultures, to be able to live these behaviors, these aspects of leadership behaviors every day in the ways that they work. So what kind of work do people do? In the work that they do we see these behaviors coming to life? So we care about what we do, but we also care about how we do what we do. So what we have done in our organization is that we have refreshed our leadership behaviors, and we have also embedded these leadership behaviors in our key processes. For example, the performance management process. Do we measure only what people do and we don't measure how people do it? Do we also ensure that they stay accountable for what it is that they have to deliver? And not just what they deliver, but how they deliver what they deliver? It is very important for us. And we try to embed all of these things. And we also infuse it in our capability development programs. So that way, people can understand what it means when we say, for example, play to win and celebrate success. Of course, how do you play as a team of one? You have to play as if, for you to play, then it means that you are a team. So it's more than one person. So how do you make sure that you're all in it to win it, but at the same time, when you do have that win, you all celebrate success as a team? That is a behavior that the leaders in those teams have to continue to foster. And secondly, what we also do, apart from that, is also to dial up capability development for our people leaders. Because we know that these are the ones that really influence, that creates the influence, or that could ensure that a climate is warm, is ambient, is hot, or it's toxic, or the culture is the right one, or is not the right one. So individuals start to bail out, even if they're not bailing out of the country, but they are bailing out of the organization, or even quiet quitting, as it were. Yeah, so what we do is actually to equip them with training, as in physical training or even virtual training, to just train them how to become people leaders. So now you've transitioned from leading processes. You've transitioned from running machines and running lines. Now you're dealing with warm bodies, with people. How do you make sure that you can lead people with empathy and with compassion? So we educate our people leaders in doing that, in ensuring that they are leading with empathy and with compassion in line with our leadership behaviors. And in training them, we're also showing them that, listen, you will be held accountable for delivering the numbers. But if in the process of delivering the numbers, you're spilling blood, as it were, on the floor, then you might be robbed of that hard delivery because of this other aspect that's suffering. So we've taken deliberate steps to make sure that our people receive both physical and online training on all of these things. And there's something else that we've dialed up, which is diversity, equity, and inclusion. And oftentimes when we talk about diversity, we quickly run to males and females, but it's beyond that. The bigger issue even comes around inclusion, having your voice heard, no matter where you are, being involved in your own work, being asked to decide on the things that you have control over, that you manage, rather than excluding you, or rather than somebody bullying you. So that's something that we take very, very seriously. And we are training all our people on what inclusion means, what diversity is, what equity is, or what they are not, and what role leaders of people have to play in ensuring that there is inclusion or inclusiveness in the way that we do things. And there's a third one also, which is encouraging our people to speak up. So how do we encourage our people to continue to speak up and not be afraid when they see that things are going wrong? And we give them the opportunity to be able to speak up either anonymously, or if they want to identify themselves, they identify. And we insist that we follow these up very, very closely. And we hold listening and dialogue sessions across different demographics to just continue to get insight from our people on what could work or what couldn't work, or what is working, what is not working. The whole idea is that we want people to be able to thrive in the organization. And by enabling people to thrive doesn't mean that, again, we are managing underperformance. But we believe that that is when these things come together nicely, that is the best way that people can put their best foot forward and give their best job yet. So that way, when individuals are struggling, it is clear they will get the assistance that they need, but then we would have those tough, courageous conversations with them, and they would know where they stand. And the process, of course, would take care of the situation as the case may be, but not first without enabling them or setting them up to succeed in the environment, particularly psychologically, because oftentimes it's not just because they want better pay. That is why people leave. Sometimes, in fact, a lot of the times it's because they've just had it up to here. They even leave the better pay and they go for lesser pay. And now, when they get the opportunity, they run out of the country to get payment in foreign currency because the naira is devaluing so fast, or staying in an environment that is secure, that has more security and safer for their families. So organizations can do a lot to reduce that tendency, to make people think long and hard as to why they would want to leave, to make it a difficult decision for them to make, a painful one for them to make before they go, such that when they do get an opportunity to come back home, they're thinking of coming back to you. And I have seen situations like that, a lot of situations where our people write back to us and they say, we want to come back. We want to come back to the organization, and we consider it and we take them where we have the opportunity. So for me, I think this is, again, it's an opportunity. We need to show up. We need to do things better, and we can start right from within us here. So it gives us a great opportunity to raise the standards, raise the bar, and really treat people, not like machines or not like lesser people. Thank you.
Wow, Grace, thank you so much. I mean, you've said so much that someone has to listen to this recording again, because you've done something beyond just sharing what you're doing in your organization. You've given some kind of blueprint. And I think that generally to make change happen, you don't need to do 20 things, really. If all organizations just sit down and say, okay, all these things that Grace has recommended, we are going to do them, I think that will cause a massive shift. And without talking too much about politics, I also think that if our government, listens to what Grace has said and what all our panelists are saying, perhaps we'll get the change that will make Nigeria a better environment to stay back in. So thank you, Grace, for that. So we'll go to Tayo. Tayo, are you there? Are you still in motion? So we hear your comment. So Grace has said a lot. I mean, there's care and there. She talked about islands of excellence. And then, a lot of emphasis on leadership behavior, leadership modeling, and, training, capability development. So gone are the days where trainings are focused on the technical skills. There's also the behavioral skills, the leadership skills, because really these things matter a lot, Psychological safety is another big topic, really, because people really leave jobs because they're not okay, they don't feel heard, they don't feel safe, and they rather just go somewhere else. And like she said, some people even quit for less pay, just so that they have that psychological safety. And then she mentioned quiet quitting, which is another topic. So Tara, let me ask you specifically. I'm a lawyer, right? And if you go on social media, you will hear a lot of things about why people leave law firms, right? I will not put everybody in the category of some other law firms. So generally, there's an issue within the legal profession, So there's a special jackpot for law firms, actually. People want to leave law firms to go in-house. People want to leave law firms to go to other countries, even where they need to start reskilling to be able to work. So you have lawyers leave Nigeria to go and do any kind of job, pending when they get their qualifications to practice abroad. Some don't even bother, practicing law anymore just because they want a better life somewhere else. So let me repeat the question that I asked Grace. And the question is, how are organizations coping with the Great Resignation? What are organizations doing to mitigate the risk of Great Resignation to their businesses? So you want to answer that, whether from the law firm point of view or generally. Thank you.
Okay, thank you, Chinwe. You're doing a fantastic job, all right? I couldn't want to start. I recognize, I think, the presence of our PRPM president, Dr. Moji. Good one. You're doing a good job, bro. Thanks for all you do for the profession. Now, so I'll start by saying that A&O is the #1 leading firm in the industry, right?
Hi, I'm here. I don't mean to interrupt you, but I'm here. So you want to rephrase one of the top?
Things speak for themselves, right? So there is the challenge of being an industry leader, right? There are many things that we're having going on that are exciting. So obviously, if this were a National Society of Engineer kind of conference, I will probably be a bit freer. But because this is a conference in the industry, right? So you want me to keep some things under wraps, right? Because we're still boarding them. Because like you said, you are an anomaly, and of course, obviously, still my competitor, right? You know. But I'll just speak to in a general sense. Number one, it's affecting all of us, meaning that all the law firms, tier 2, tier 1, even no tier at all, permit me to say that, are really having the issue of lawyers, associates, senior associates, actually really, really moving in their jobs. So they're either going to multinationals or larger corporates, or very, very, should I say, secure and dependable startups, right, that have raised funds and are able to pay dollars sometimes and also provide some better level of flexible working that more than traditional development, right? And then you have really moving to do their masters, either master LLM or you have
Chinwe, I'm not sure how is it.
Right, family relocation, or just moving, and like Chinwe said, just wanting to get out of this climb, get abroad, start something, and just then find their footing. So we're faced with this as well in A&O. But for us, we've looked at it and as part of our response, one of the things we're trying to do is to ask ourselves how, in the context of everything that we are providing and how we're trying to build a culture that's a great place to work, and we're trying to attract and retain the best of mind, to keep in mind 5 things for us. And that's number 1, potential, number 2, passion, number 3, pressure, number 4, power, and number 5, platform, right? The various things that we're doing, like I said, I might not be able to speak specifics to, and some of them already started, some foundation laid, and 2023 we are pivoting at an amazing level. And the fact that we're asking ourselves, that how do we provide a place where, number 1, people are young talent, Gen Zs and millennials, believe that they are going to have their potential unleashed. And what are the things that we are putting in place to be able to ensure that if we will be rated on that metric as an organization of potential, people will want to rate us high and say that A&O is a place where my potential, I'm discovering more about myself, and my potential is being unleashed. And of course, that ties into direct things, right? Things like being able to ensure that even our millennial leaders and millennial managers understand and are equipped on how to lead and manage other millennials. Because that's one of the things. So if you look at it in the context, people that are associates of 10 years, of 8 years, of 12 years are actually millennials, right? And you find them already leading other millennials. So the context of even leadership and management of maybe a Gen X or a baby boomer leading a millennial or a Gen Z is totally, the context are totally different in the mindset and the thinking of a millennial leading and managing a millennial. That's one very key for us. We're also asking ourselves, how does A&O become a place that is an ignition, right? That ignites our people. So it's like trying to make the conversation so difficult for them, right? I mean the consideration for Japaism. And even when it happens, they are so engaged and pumped with us that they want to start the conversation early and understand that, oh, how do I even replicate myself? Or how do I, have a 1-year conversation and say with my line manager or my supervisor that this is what I'm thinking and these are my plans for next year, and they get carried out, which helps us with sustainability, we helps us with succession planning, we helps us with being able to actually even evolve or adapt or see how we can accommodate some of their own realities and be flexible. So how do I, when I come to job every day, how do I have a place that lights me up? Okay, so we're keying in different strategies that we're deploying for talent retention around that. Number two, pressure. For us, we're not shying away about professional law services, right? And it means that just like the people in consulting, we beat our chest and say, yes, we're high intense environment, like you will know, Chinwe, right? The tier ones are high intent, right? So, but we want to say we want to be high intent for the right thing. We want to be high intent in a healthy way, all right? So when we say pressure, yeah, we're not shying away from that word. Bring it on, okay? But we want to be a place where when people think pressure, they think of stretch, right? So how does being in A&O, I know anybody as a talent and an employee, how does it stretch me beyond my comfort zone? How do I get on committees? How do I get on projects? How do I get on assignments? How do I get on secondments? How do I get on job rotation? That beyond all the things that are on my plate, right, gets to really stretch me out of my comfort zone, okay? And then, how do I get power? We're also not shying away from it, okay? How do people feel empowered? That they get to feel that they're equipped, okay? They don't feel helpless. Our associates and senior associates don't feel that we are asking them to go to war without providing the tools that sharpen them. So for us, we are reskilling, we are upskilling, we are intentional about our trainings. We are very purpose-built and learner need focused, right? So it's gone are the days where training is just for training in itself. Now, A&O is probably the only law firm in Nigeria that has the largest HR department, and I feel that because it's not for the numbers, right? And has senior people leading the department, not because of it's because A&O has seen something, and other firms are trying actually to catch up. So before, probably law firms, you have either mid or very junior people, they pack HR and admin, pack them together, just go doing anything, right? In A&O, right, the transformation started from HR, and that's why the nomenclature is people and culture, just not because to sound fancy, but because we're actually leading in the industry. Yeah, we know that people are going to be taking some leaf of our books and duplicating some stuff. It's okay, right? But we're leading, right? We're leading the change and we're leading the transformation, right? So we're asking ourselves power and then platform. How do our people, how do my talent come to work and they feel that, A&O gives them a voice, gives them resources, give them platforms to express themselves, right? To showcase, apart from their passion for law, other things that they are passionate about, right? So we're more deliberate. Gone are days when associates participating webinars or taking some technical shows were just a tick in the box for KPIs. No, for us now, there is more intentionality about it, of empowerment, there's more intentionality of engaging them for platforming, right? So that when the conversation arises around, jackpine or great resignation, it even gets to be a win-win as, okay, what are the plans? Where are you even going to? Time difference-wise. And then do you see yourself, right, being able to be still in the community, our talent community, or still stay employed while you can provide really, the value you have for the conversation. So for us, we see even our top talent either wanting to explore, right, still being with the firm wherever they are, because now it's now a response, right? It's a response to their what they've seen about what the value the organization is bringing for engaging talent. I think that a lot of the things we are on about, in 2023 is an exciting year for us to do more on them. So those are some of the things we are doing.
Yeah. Tayo, all right, sorry, Chinwe, one second, so that we just need to manage the time a little bit more. We're running out of time. So we will need to get to the questions very quickly. But just to tweak it ask a very specific question to Chizoba here, and coming from your consulting perspective, right? A very specific question, right? Would it be fair for organizations or other firms, governments, all forms of employers, would it be fair for them to essentially, in hiring, rethink what their pool would be? And I'm asking this specifically because of your earlier interesting opinion about how we should have seen this coming, how people are being denied opportunities. So, for instance, should an employer say, you know what, I'm going to target a certain class of employees, maybe those who have been out of work for a while, or older people who are not likely to be moving or looking for other opportunities out there. Would that be fair, or would that be opportunities to these young people, like you said? And very quickly, we can then get to questions, because we are nearly out of time.
Okay. I think, and I'm glad that the president of the Chartered Institute of Personnel Management is here. This is the time that you need human resources. Nobody goes to, if you have an issue, a legal matter, you go and look for a carpenter. And that's what organizations have been doing. Hiring people who are not licensed HR people, or people who are not professionals into the HR roles. And that's why we are where we are, you know, as a country. Until we recognize that human resources is a profession, and human resources will guide you in the management of the people, how you set out that strategy, hire the people, manage them, exit them, and how to deal with situations like this. We're just going to continue to be in the mess that we are in. And the public service hasn't understood the importance of human resources, and I'm hoping that they will catch up. Maybe because they are not facing the great resignation, because they haven't been hiring young people, so they really can't understand that. Back to the specifics which you have, you've asked. So for the future of work, there are three things that are changing. The nature of the work itself in terms of automation, the workforce itself, the definition of who's in the workforce. So that definition of the workforce has to expand. So when we're talking, I'm not talking permanent membership of a workforce. We need to expand it in such a way that if people have the skills that we have, create the platform for them to be able to do that activity or that particular thing that you want them to do, and then they get the hell out of your way. Because it's not everybody that we have in the organization. So we hire people permanently. Like I told you, I'm a table shaker. You hire people permanently, whether their skills are still required or not required, we have to keep them in the organization, we have to manage them in the organization. So we need to start thinking like the gig economy. What people do we require at each point of this gig, you know, for them to be able to provide service? So there could be even the people who have resigned because they've got a skill, they've got extra time on their hand. Remember, this is a generation of hustle. So they are not looking at just work. There's always a side hustle. So their side hustle could be your organization providing 10 hours of work for you, or providing 20 hours of work for you. So you don't have to have these people in your payroll. And then in terms of workplace, the workplace has been, you know, decentralized, disaggregated, so people can actually sit wherever it is that they are and provide service. Currently, I'm working for 4 different organizations, but I'm not in their payroll. So they pay me on a daily basis. They pay me my daily rate, my daily fees. And then when I go to the client's place, I wear their uniform. I wear the context in which they want me to operate. And so that's the future of work. That's the noun of work, and that's what we need to explore.
Yeah, thank you. Thank you very much, Chizoba. So I would like...
let me take it from here, Chibike.
Yes,
in terms of the question. So interesting point Chizoba has made, and entire alluded to, you know, encouraging people to continue working for the firm even when they're abroad. So I don't know how HR sees having multiple jobs, but Chizoba has explained her gig economy example, you know, not being full-time. I guess the challenge would be when someone is full-time somewhere and still holding on to another job somewhere else. So that's another issue to think about, because time is also...
So the question, Chinwe, is what is full-time?
Yeah, full-time is what
because
it
I
is.
work 8 to 5, and then I've got from 6 p.m. to 10 p.m.
No, but your contract clearly shows that your contract is based on your output or whatever you're giving to the organization. Is not tied to the hours, where it's like, yeah, so great example you've given, Chizoba, and I think that's another thing for organizations to think about. So I have one question online, and I think we can take one at the venue, Chibike. I don't know how many people have indicated interest in asking
please
questions.
indicate if you would like to make a comment or ask a question. We want to take one online, and then we'll come to you, sir. Chinwe,
yes,
please
and
go
I
ahead.
think after those 2 questions, we'll now have our panelists give their final remarks and close the session. So let me read out a question from Ehiji Mentor Oriere. Person says, considering the fact that when skilled employees leave an organization or the country as a whole, what should government organizations do to fill up the spaces or vacuum created by the jackparists? So that's another term, jackparists. So I'll ask Chizoba and Grace to answer. So for government, really, I think this question speaks to succession planning. Chizoba, you already mentioned that the government are not employing young people, so I don't know. What should government do to fill up spaces of vacuum created by jackparists?
Okay, before we go to the government, because I cannot hold brief for government. Yes, I've worked in public sector, and my work continues to be in public sector, but it's about really supporting public sector to start thinking about things differently. But from an organizational point of view, what we really have with the Great Resignation is a development problem. How are we developing people, and then also in terms of manpower planning? There was a time where we used to hire a bit more than we required because we needed to keep people in the pipeline. And then also in terms of recruitment, we are constantly, rather than recruit for a specific position, look at the pipeline of people that we could keep tabs on, to be able to tap them back into the organization. And yes, you did mention that we have a succession planning problem because you can actually, these people who are leaving, they had given indication. And so there are people that you see that are at risk of leaving. Then why are we still leaving only them in those jobs? So we need to start growing and developing people. And then also to just make sure that all our development is not just only for the specific area, but we have a much more broader based development. From the government point of view, I would think, this is a time for a lot of conversations. Because until you understand what's going on, have data for what's going on and why it's going on, anything that you're doing is just putting iodine on your wound. Okay? So we need to start having the conversations, engagement with both private sector, public sector, even individual groups, diversity groups. But I will also encourage organizations. Somewhere that we are not looking is people living with disability. We're not hiring enough of them. We're not. There are people, they've got the qualification, they are likely to stay a bit more longer, than other people. So why are we not tapping into that pool? We need to tap into that pool. We need to make sure that we are recruiting, actively recruiting from that pool. And then start the development, and start, pushing into that pool, helping to develop them, helping to keep them warm in the pipeline and bring them, whether they are visually challenged, auditory challenged, or physically challenged. Thank you.
Wow, thank you so much, Chizoba. I like that you mentioned the differently able people in terms of inclusion and diversity. It's not just the gender diversity and inclusion. There has to be that about people living with disabilities. Thanks so much. Grace, do you have any comments on this?
Yes, very quickly. First of all, I couldn't agree with my co-panelists more based on everything that they've said. I think the thing to do also is how fast we can recruit. We can reduce our time to hire. We can also, we've been challenged to say, why must we ask for things like first-class degree, second-class upper degree? Nigeria, as it were, the unemployment rate in Nigeria is rising and rising, even with this Great Resignation. So that gives us food for thought. That means that there's room to hire more people. Yes, is it going to be costly to train them? It's going to be a bit more costly to train them, especially given, the education system that we have. But that is something that employers should be ready to do. And that is something that I believe that employers can, that is one way that I believe employers can actively contribute to nation building. Because when you train these people, you are really actually building national capability. So for example, we have our training school, and to Chizoba's point, we always hire more than what we need because there is time required to train these people. So it's something that we've been doing and we continue to do. And with the great resignation even coming closer and closer home, what we've done is to take a long shot at what our needs would be, and we've deployed strategic workforce planning to be able to help us see the kind of profiles we'll be needing in future, where we'll be finding these profiles at, and what do we need to do right now to be able to identify them. We have a special advantage in our organization because we are part of an international organization. So that means that we get to export talent legally. Well, for want of a better expression, they are not jackbarring, as it were. They're going to other operations within Heineken to support them. And we are very proud to say that we are net exporters of talent. So what that does for us in Nigeria is that we have a lot of our people out there on short-term assignment, long-term assignment, and even sometimes on local contracts in those countries. So we give our people the opportunity to go abroad, but go abroad into Heineken. So that way they're still being developed, you know, somewhere within the Heineken world, not just going completely out of the system. We have the opportunity to be able to do that. So when that happens, we're able to backfill those roles with people from outside. People internally, and then get new people from the outside as management trainees, as operators. And we have actually a tie-up with ITF and NECA where we're developing and training people technically. And we've had that relationship for some years now, where we're really consciously developing people for them to be used by other industries as well. And to the point that Chizoba made about skilling up people, not just for specific things, but multiplicity of skills, I couldn't agree more. We are also doing that with our technical people, where they're able to do operating work, they're able to also do electrical work, they're able to do other technical work, and they're able to run machines end to end, as the case may be. That sets them up for growth in other areas, and they can easily go abroad and still have the comfort of knowing that they are abroad, well sponsored, and they can come home anytime to take on a bigger job. But really, 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 as employers, we need to do more, and this gives us an opportunity to do a lot more. Is it easy work? No, but it is meaningful work, and it is fulfilling work for us, knowing that we're contributing in a positive way to nation building and not just paying lip service. Thank you.
Thank you, Grace. Chinwe,
Grace,
we're going to have
over
to go to the live audience here.
Yeah,
We've got
sure.
one comment at least and another. Please, sir.
My lords, Learners and Advocate of Nigeria, moderator also, I welcome you, and the panelists. I want to make this point, and I want to make it very pungently. It seems as if taking into consideration the provisions of the Constitution, the fundamental objective, and the directive principle of state policy, you see, there is nothing that we can do about it. There must continue to be jackpot, continue to be exodus. We need to address the socio-economic policies of the country. Once that is not done, there's nothing you can do about it. Because, and our courts, especially the trial courts, not National Industrial Court too. Where you go to court to say, oh, let the government implement the fundamental objectives and direct principle of state policy. No, it's not justiciable. It's not justiciable and the rest of them. If our take the bull by the horns to say, look, Chapter 2 of the Constitution should be enforceable, then some of these things, you know, we will be able to solve some of these economic problems. And again, look at Central Bank. Recently, they said interest rate has increased 15 to 60%. They started recently. What of those in the private sector that have taken loans and overdraft? AMCON will come and take over that company and the rest of them. So all these have what I regard as a spiral or a multiplier effect in respect of, you know, retaining workers and the rest of them. Because if an organization is not moving forward, how can they still be retained? So I think that's an area we need to address very profoundly and fundamentally. The economic policies of the government must be well addressed. Thank you.
There you go. Yes. All right, I'll just go to him, please.
All right. Good afternoon, everyone. I think it would be appropriate, since we're talking about the Great Resignation, I'm young, so I think I'm Gen Z. Yes. So, I mean, kudos to the private sector, right? There's a lot of pressure on the private sector because I think they're the most affected. But the other sector we're forgetting about is the public sector. And at the end of the day, these guys become the policy makers, right? So whatever we do in terms of creating retention strategies in the private sector, implementation will come. And so my question is basically how are we engaging the government, right? We just can't keep saying, okay, government ought to do this. What are the practical steps we're putting in place to ensure that we engage the government in terms of implementation and how? Because some of us love Nigeria, right? I mean, we all sing the national anthem and we want Nigeria to work. Not everybody will leave the country. Some of us will want to go, but probably just for vacation. We want Nigeria to work. So what will happen if almost everyone has gone? We are the future of this country, right? So we'll just switch off the light and just go. So my question is practically, what's Nba-Sbl, the Labour Committee, doing to engage government in terms of, implementing policies that would retain talent, because we need Nigeria to work?
So there are many of us who are human resources people who have left private sector. So my tenure in Central Bank ended 2019. We have a tenure limit for directors. So I joined as a director of human resources in 2011 from ECOWAS, and it ended in 2019. So since 2019, I could have gone back into employment. I was only 51 at the time, my employment ended. But I've decided, that it's my life purpose and work to try and get public sector to understand human resources. And so a lot of my work is with public sector organizations, both at the subnational level and at the federal level. So these conversations, we're having it. A good example is a state that I'm working with now where they've built an academy and we're talking about the programs, around the academy. So one of it is about understanding, the laws, the regulations, because the people who put in these regulations, I made a comment that hire HR people, we're professionals. So sometimes in the conversations around these labor laws, talk to us. Which is why SBL is doing this. You've got to talk to us. We live with this every day. We are professionals. We can give you our own perspective. Because law is not law. It's not the legal language. The law is the principles, fundamentals of an issue. So everything that we have as a policy, as a law, has a principle in human resources, especially as it affects the labor. So yes, we talk about compliance to labor law for human resources, but a lot of those is fundamentals. Why would you write into the labor law that people should come to work by 8 o'clock? Maybe 10 o'clock is not, maybe 10 o'clock in future is going to be the time. So if you're saying 40-hour week, please, 40-hour week is 40-hour week. Be silent on the resumption time. Because, that's my work may start by 10 as long as I do the 40 hours or I do my 8 hours per day or whatever it is. Okay? So these are fundamentals. Talk to the human resources. And like I did say to you that the human resources function in public sector is not there. It's not there. They have the title, but not the people. So we've got to professionalize, and that's why CIPM's been doing a lot of work with the Federal Civil Service and the subnationals to try and for people to understand that human resources is a profession. And then we can then now engage in the conversations to make sure that the public sector understands and then can now create the frameworks and the policies. But it means also that our head of service got to be a HR professional, unfortunately. And then the Federal Civil Service Commission and all the state service commissions, they've got to be licensed HR professionals for it to work. If you go to other clients, that's how it is. They are professionals. You will not carry a Minister of Justice. You will not make me Minister of Justice. So for as long as you can't make me Minister of Justice, then why are we making the Civil Service Commission and then making the head of service a non-HR person?
Please come.
Okay, is there someone asking a question? I want to call Chizoba a licensed table shaker for good cause. For good cause.
Good afternoon, everyone. It's been a very interesting conversation, and I think just thinking about it, if you look at most of the reasons why people leave, it's basically economic and safety. If you ask people, why are you leaving? They'll tell you they're thinking of their children, they're thinking of their future. A lot of them leave and start doing jobs they would never do in Nigeria. And so you now ask yourself, why would a professional leave and then go there and start cleaning or waiting tables? I think the most important thing is knowing that we need to work together, both private sector. I'm from NECA, and one of the things we advocate is for us to work together with government in order to create policies that will create an enabling environment for businesses to thrive. If people have alternatives, if I work for an organization, thank God, Nigerian Breweries is a conglomerate, it's a multinational, but how many organizations are multinationals and take the time to put in place things that will make people stay? But if I have an alternative, I don't have to go out, but I can move to somewhere else. So there's a need for us to have an environment that doesn't stifle entrepreneurship, it doesn't stifle business growth. So there's need for government and private sector and others to work together to create the policies we need to grow. Thank you, that's my comment.
And then if you have any more, you let me know.
Sorry, I wanted to respond
just the
because
comments here.
there was
a
question as to what Nba-Sbl was doing, and I needed to respond to that part. We are here today as part of the interventions that Nba-Sbl have tried to put in place. A couple of months back, we had a bar bench engagement with the National Industrial Court judges. For us, we have become very deliberate and intentional with respect to our interaction with the Ministry of Labor. And the legal advisor to the Ministry of Labor was here today. As individuals, there are things we can do to start the conversation and to shake the table, if I may use the word of Chizoba. It shocked me when I put out an article and I spoke to the Ministry of Labor about maternity leave being independent of annual leave. And everybody, Ministry of Labor, the senior officers there said to me, no, this is how we've always done it. If you take maternity leave, you can't take annual leave in the same year. But I struggled to explain to them that both leaves are independent of each other. Annual leave is covered by Section 12 or 18. Maternity leave is covered by Section 54. If the intention of the law was for both of them to consume the other, there will be a proviso to say if you've taken your annual leave, Section 54 maternity leave will not apply. Or if you take maternity leave, your annual leave will not apply. I also understand that conversations could be had between the employer and employees to agree as to how this is taken. But in the main, some of these conversations, we need to start having them. If we do not stir these conversations, perhaps people don't know because of ignorance, or they choose not to know, but we need to start stirring that conversation. And that was why we are here today. And we also encourage that you also join the conversation. You have a role to play. If you stir the conversation, we can take it further. But in the main, we need to keep the engagement going. And thankfully, we have CIPM here as well. And the point has been made that we need to have trained, competent HR people managing HR positions. And if we don't have these conversations, we can't get to that point. I just needed to clear that. Thank you.
Thank you.
It's silent on premature birth. And this maternity leave was discussed at the time when women were not in the workforce. So these are conversations that you must have with the people who are leading it for you to then now look at the scenarios that are going to work. And so I'm glad that at least the lawyers are leading it, but please make sure that the other leg of the conversation, which is human resources, must be in the room when we're engaging labor.
Thank you very much, Chizoba. Thank you. Unfortunately, regrettably, actually, we've overshot our time. We're going to have to start wrapping up. We understand this has been very interesting for everyone. So we want to thank you all, first of all, our live audience and everyone who has commented. To the Leonard Silk's point, I'll be curious to see how the courts will enforce Chapter 2. Will they award damages? Or will the Supreme Court sack the government? I find that option of sacking the government, I like it. But really, we thank you all. We thank our panel. Chizoba, thank you very much. Grace, Tayo, thank you all so much. I personally like the spin that our panel has given to this. On one hand, it could be a threat. On the other hand, it's an opportunity. Like someone has said, there are 2 Indian prime ministers in the world today, one in the homeland and one seconded to the United Kingdom. Who knows? What we call the Japa today might well be what saves us in future. So thank you all so much. Mary, I'll let you take this go.
Thank you all.
Thank you very much. Mrs. Mojeku, please come back. We have to take pictures. Okay, Miss Mojeku. Not Miss. Miss Mojeku. Fantastic.
MISS.
Are we part of this photograph, Mary? Thank you all.
Thank you all. Thank you so very much. We're now entering into the last panel of the day, and the most interesting, if I dare say, it's conversations on international best practice. And we have the privilege of having 2 justices of national industrial courts with us. And so we're going to hear from the dispensers of justice as to what you should take into consideration when you're looking to apply the international best practice in your workplace. What exactly, or when as an employee you're looking to enforce that. And we have Mr. Falabi Kutisan. He is the moderator of this panel. It's my pleasure to introduce Mr. Falabi Kutisan. So I will say a few words about him before I shouldn't bother. Ah, fantastic. Thank you very much for sparing me this. So I will start with her Lordship, Honorable Justice O.A. Obaseki. He's, okay, sorry, I'm sorry. I'm sorry. Thank you very much, Her Lordship. Her Lordship. Yes, ma'am. Her Lordship was appointed a judge of the National Industrial Court in 2008. Before her elevation to the bench, she was actively engaged in corporate legal practice and consultancy services between 1986 and 1992 with the firms of Debo Akande and Co. and Chief B.O. Olowo Foyeku and Co. Olowo Foyeku. Okay, I hope so. In 1992, she joined the services of Tafawa Balewa Square Management Board as Board Secretary Legal Advisor. Given the federal government's privatization and commercialization exercise, a new company, Tafawa Balewa Square Investments Limited, was incorporated to take over the functions and duties of TPSMB. And between 1992 and 2000, her lordship served as company secretary, legal advisor of the new company, and rose to the position of assistant general manager. She thereafter went into private legal practice between 2000 and 2008 before her elevation to the bench. And her previous experience in the practice has, of course, served her very well. So it is, of course, my honor and my privilege to have Her Lordship join us. Thank you very much. We also have Her Lordship. Honorable Justice O.Y. Anuwe with us. Justice Anuwe attended Christ the King Catholic Primary School from 1968 to 1973, and of course went to the prestigious Nba-Sbl University, Zaria, where she obtained her LLB in 1986, before her call to buy in 1987. She obtained her LLM in 2006 from the University of Jos. Her primary NYSC assignment was at IBM Haruna and Company Chambers, from where she moved to Ori Fumishe and Co. Solicitors, and was associate partner and head of chambers at Ori Fumishe and Co. Partners. She moved to the National Industrial Court in 2006 as Assistant Chief Registrar, and from that she was appointed a judge of the National Industrial Court in May 2013. We also have with us Mr. Roland Otaro, SAN, PhD, who has been with us this morning. Thank you very much, sir. He's the principal partner at Otaro and Co. Legal Practitioners, and a seasoned legal practitioner in practice. He was called to Nigerian Bar in 1985 and obtained his LLM in 1997, and later obtained his master's in industrial and labor relations. He's a fellow of the following bodies: Chartered Institute of Arbitrators, Nigeria; Chartered Institute of Capital Market Registrars, Nigeria; Chartered Institute of Administration, Nigeria; and a member of the Chartered Institute of Arbitrators, UK. Very impressive CV. Thank you, sir. We're very honored to have him with us. And we do have someone who's going to present the perspective of the practitioners with us, and he's no other than the president of the CIPM, Mr. Olusegun Mojid. Mr. Mojid is an alumnus of the prestigious Yale School of Management and the executive consultant and global head of practice at Bizale Consulting Group, the HR company he co-founded with his wife in 1985. He holds an MSc in Industrial Relations and Personal Management from the University of Lagos, and he is a thoroughbred licensed global human resources learning and talent development practitioner. He's a 2006 Merit Award winner from the Chartered Institute of Personnel Management, of which he's currently the president and chairman of the Governing Council. Thank you very much, and we look forward to a very invigorating conversation this afternoon.
Thank you very much, Mary. I'm actually looking forward to that invigorating session. A very good afternoon, everyone. A very good afternoon, everyone.
Good afternoon, sir.
Yes, I'm sure we've not had lunch and never had the distinct pleasure of hosting or moderating a panel after lunch. You don't get the usual response from the crowd at that time or the audience. So, very good afternoon again. I'm sure we've had an interesting time right from this conference started in the morning. From the first session dealing with the outmoded Labor Act and sharing perspective on what can be done, to the second session on the Great Japa with Chizoba, the table shaker, giving us rich perspective as to what and why this will continue. Now, taking away from all that, this session is situating the world of work, even in this terrain, within international best practices, global best practices. And so, thankfully, I mean, it's a session that, it's a conversation around international best practices, but I think a lot of what we'll be discussing would provide or attempt to answer what the concerns are with the other two sessions that we've had. Because we'll be discussing how, for instance, adjudication of disputes in this climb can be seen or is being done from the context of what obtained in other terrain, I mean other climes, within the context of international best practices. And Nigeria being a member of the global community and the International Labour Organization, it is rather very important that what we do here is seen in the context of what obtains within international best practices. And to drive the conversation, let me draw us back to what I recall that the president of the Industrial Court said at as part of his opening remarks at the 2022-23 New Legal Year celebration, in giving an historical perspective as to how or why the Industrial Court here can try disputes submitted before the courts and apply international best practices when sitting on such matters. And in particular, my Lord the President had made reference to the Section 7 of the Establishment Act, which allows international best practices to be taken into consideration as, and ultimately, I mean, 254 of the Constitution, has been taken from, or been borrowed from Section 10 of the Industrial Relations Act of Trinidad and Tobago. And that, I mean, that was taken from it that, in the context that in the adjudication of dispute, the courts can apply international best practices. And that international best practices will be seen as a question of fact. So, I mean, it's based on more like case-by-case basis to be able to bring the context of how would it be addressed, how is this being done globally. And that that question of fact aspect was introduced so as to ensure that matters like that, once decided, you don't go on a frolic of an appeal. And you can only go on appeal with leave of the appellate court. And quite a number of things and how we are where we are today. Now, let's bring it home. This panel, or this session, will be having a conversation around international best practices from the perspective of the courts, from the perspective of the practitioner, and from the perspective of perhaps a sector that is expected to be more involved. I mean, to draw from what Chizoba said, we can't be making any law about labor. We can't be having conversation about labor without getting HR involved. And thankfully, I think we have the CIPM president to also have a bite around some of the issues around international best practices here. So it's not my session, so I'll go straight to my Lord. I'll start with my Lord. The first question, international best practices and the national industrial courts, says that by the virtue of the provisions of 254C, 1 F of the Constitution, the National Industrial Court is conferred with jurisdiction to adjudicate on dispute relating to or connected with unfair labor practices or international best practices in the Nigerian labor industry. Now, the categorical question is, how well does the NICN or the Industrial Court try to situate the applicability of international best practices within our local circumstances? Earlier on, they were talking about the Labor Act being 74, 1974 Act. And then the practitioner comes before the court, hoping to say this is what section 10 section of the Industrial Code, of the Labor Act says. And I mean, generally, within our local circumstances, my lord, how well does a court take that into consideration? Thank you so much, my lord.
Thank you. When we're talking about, when we're talking about international best practices, we cannot talk about international best practices without first of all understanding the intendment of the provisions, both in the Constitution and the Establishment Act of the National Industrial Court. The purpose for the best practices provision, both constitutionally and in the statutes, is to bring the labor law, the 1974 labor law. And I would just say this as a side remark. The amendments, proposed amendments to the Labor Act have been in the National Assembly for years. That's part of the problem. And nothing has been done. Now, bring the Nigerian labor law in alignment with international law. And I put international law in quotes and say international best practices. And this is not strange because if you look at the Constitution, Section 19 of the Constitution, the foreign policy objectives of Nigeria, one of it is to respect international law. Particularly those laws, those treaties, those conventions, protocols, recommendations that Nigeria has signed, Nigeria has ratified. So there's no running away from international best practices and its application in labor. Nigeria is part of the global community. The global community cannot be in the 21st century, in 2022. We're going to 2023. And then the labor law will be in 1974. That is the intendment of international best practices. And when we have disputes that come to court, the facts of the dispute determine the international best practice that is going to be applicable. So the facts of the dispute forms the base for the application of international best practices. And what has the National Industrial Court done with international best practices? The application of international best practices in dispute resolution has been used to strike down issues of unfair labor practices. So, for example, we were talking about, is it maternity leave? Just yes, In fact, no, recently we're talking about, the previous speaker was talking about maternity leave, that the maternity leave provision in the Labor Act is 1974. And so much has happened. At that time, there was no consideration with respect to stillbirths, with respect to premature deliveries, with respect to women who become very ill, even during pregnancy and after pregnancy. So all those issues were not taken into consideration. Now such matters come before the court. The court can sit down, look at it, and decide whether or not to apply international best practices. You know, Section 7 of the Act talks about the fact that the courts, in resolving disputes, should have due regard to international best practices. And international best practices is a question of facts. Now, when you're talking about international best practices being a question of facts, we know that the conventions that Nigeria has ratified, the International Labour Organization conventions ratified by Nigeria, the protocols, the treaties, the recommendations, all those are evidence of international best practices. So where the country has ratified a convention, say for example, Convention 187 and Convention 190, which Nigeria has just ratified. I think it was November 7. The Minister of Labor went to Geneva to do all of that. So conventions like that have become part of our labor law. Such conventions, you do not need to plead in your pleadings because it's part of our law. But those conventions that are not ratified, and when I'm talking about ratification, I'm talking about labor. Because of course somebody can talk about, oh, but those conventions have to be domesticated. Not when it has to do with labor issues. Conventions, treaties, and protocols that deal with labor issues by the provisions of Section 254C, 1, H, F, and Section 2 do not need domestication once they are ratified by Nigeria. So once they are ratified by Nigeria, they are already evidence of international best practice, which we can go on to apply. But where it is not ratified, for example, the Convention on Termination of Employment, where it is not ratified, and you want the court to apply it, then you have to plead that convention. It must be in your pleadings, because the law says it is a question of fact. And that convention is yet to be ratified. But it is an evidence of international best practice. So you have to plead it in your statement of facts and then prove it. I don't know whether I can continue or whether I should stop for now. I should stop for now. Thank you.
A round of applause. Wow. My Lord has given indeed a very rich and broad perspective to the question, which is essentially focused on what the court takes into consideration. And then my Lord has gone to not just give us what the court takes into consideration, and also offered useful hints as to how to even bring evidence of this international best practice or practices before the courts. That leads me to my second question, which I'll be posing to my Lord Honorable Justice Anowe. And it goes thus, my Lord. The provision of Section 254, I mean, still the same provision of the Constitution, and Section 7 of the National Industrial Code Act have been celebrated for the additional powers they have granted the National Industrial Court to apply international best practices and international labor standards in determining disputes between employers and employees. So we started in the morning with the Labor Act, but thankfully we are now discussing that the Establishment Act and the Third Alteration now fortify the courts to look beyond the local Labor Act. Now the question is, are the courts circumscribed by other considerations? I mean, some of which I take that my Lord and Justice Obaseki Sage has addressed, but in particular, this part of the question is, are there steps that employers must take to benefit from the provisions of the law? And the reason for that is not far-fetched from the common take that what is international best practice is often mirrored from the misconduct of the employer, as opposed to hardly does the inaction of the employee comes before the court and the question of international best practices or best practices being discussed. That's okay. Are there things that the employer must do or areas that the employer must do also begin to benefit from international best practices? Thank you, my Lord.
Thank you very much. Now, a lot of what my Lord Justice Obaseki Osagaye has discussed relates to this question. So I'll just keep going through the issues relating to Section 7 of the National Industrial Court Act, which specifically refers to the use of international best practice in labor and industrial relations, and which ought to be a question of fact. Now, once a convention or treaty has been ratified by Nigeria, it becomes applicable, and it takes away the need for domestication as prescribed by Section 12 of the Constitution. So it kind of, I mean, if you look at the wordings of Section 254C, 1 and 2, it starts with the phrase notwithstanding any other provision in the Constitution. To me, I take that to mean that I can do away with Section 12, and then I do not need domestication to enable me apply an international labor standard, basically. And of course, I also have to look at the facts. Now, the other part of the question is whether the court's powers are circumscribed by other considerations. And I would say that the ratification essentially gives the courts the right to use those standards in adjudication. And I do not think the court's powers are circumscribed in any way. And then the steps employers must take to benefit from the provision of the law. I listened to the earlier speaker, Mrs. Mojeku, the HR expert, and I'll toe her line and say that HR has a huge role to play in what employers must do to enable them to benefit from the provisions of the law. The HR would naturally guide the employers to know what they must do to comply with those standards. And of course, the HR will not work in isolation. If the standards are complied with, the conventions are complied with, of course, there will be they would naturally benefit from the provisions of the law. There won't be any need for any back and forth on the issue. Basically, the only snag that will give a strict application to the need for a stricter application of facts is the fact that a convention was not ratified. So for as long as it is ratified, we have a smooth sailing ordinarily.
In a few cases, just like my Lord Obaseki has pointed out, like Convention 158, in cases of termination without reason, we generally hold that the reason must be justified and established. And that is just, basically, even though Convention 158 was not ratified, it still forms part of the international labor standards already established by the ILO. Well, I don't know if that would do for now.
Yes, my Lord. Thank you so much, my Lord. Please, a round of applause for my Lord. For the great insight shared and in the answers given to the question posed. All right. I take it that we've listened to the courts. My Lord, this is the only opportunity I get to pose questions to my Lord without being cited for content. So, my Lord, thanks so much, my Lord, for the privilege. And I'll take it away, and now let me take it to Dr. Taro SAN to give us a practitioner's perspective. First with, the conversation that we're having around international best practices. What are your preliminary thoughts, sir? International best practices. There's a major question I'll bring a month later to you, sir, around compensatory damages. But for now, what are your preliminary thoughts around the international best practices? And sir, and Mr. Moji, the same question I'll be asking for your preliminary thoughts, sir. Okay, sir.
Thank you, my lords. My lords, they have spoken very eloquently, very eloquent expose of what constitute international best practices. I want to say without any equivocation that the best that has happened to the employment market law in Nigeria is the use of international practices in adjudication. There in this case I did is I think it has changed the narrative in the jurisprudence of labor law. And I regard the provisions of section 7.6, 13, 14, 15, 16, and 19 of the National Industrial Court Act, and the provision of section 254C, F, and H of the 1999 Constitution as amended, the legal and constitutional anatomy of the jurisprudence of the jurisdiction of the National Industrial Court. In Sahara Energy Resources Limited and Oyebola, which was edition of the Court of Appeal, were delivered 2 years ago, says that, one, you cannot just go to court and say, oh, you want the court to use international best practices. But your claim must be predicated on facts. Not only that, it must be a claim that you are asking the court. Because what is not claimed by you, or a relief that is not claimed by you, you cannot, the court cannot give it to you. The court is not a Father Christmas. Have regard to the decisions in Green and Green. There was a decision in the case of Nasarawa Specialist Hospital Management Board and Mohammed. He won at the trial court. The court awarded 2 years' salary. But on appeal, they said, no, you didn't claim it. How can the court award what is not claimed? But in my own case, I claimed a lot of reliefs. I even claimed general damages. And what I want to sell to our colleagues here today is that there is nothing wrong in claiming many reliefs. Just claim it. Yes, claim any relief. The court will decide or the one to give to you. But if you don't claim at all, the court will not give you. It's like Nemo dad, quote not, habit. What you don't have, you don't give. If you don't claim, nobody is going to give it to you. And I raised a point in that matter, and we lawyers, we are familiar with ubi juice, ibi, remedium. When there is a wrong, there must be a remedy. And that is encapsulated, I would say that that principle of law is in a way treasured in international best practices. I raised it, I said, a wrong has been committed by the employer. And since a wrong has been committed by the employer, there must be a remedy. And the court agreed with me. And that is provided even under the National Industrial Court Act, under Section 13 or 14, that the court has the jurisdiction to grant any remedy. Any remedy. And so, that is the best that has happened to the labor force. So I think it's a very good, a good enactment, because a lot of employers, what they do to employees, you know, is unbecoming of some of these employers. So I think, and the National Industrial Court has been doing that over time. Like for instance, the case of Bello and EcoBank, when they use the termination of employment convention of that is number 158, which my lords have referred to herein. That decision was given sometimes in 2018. And my Lord Joseph Aluwe stated it that, well, the two of them even stated it. Even though you don't have, if you, once you plead it, even though it's not enacted or it's not ratified by the government, by the federal government, then it can be used. Section 254 actually encapsulates everything that has to do with international best practices. Although international best practice is not defined in the Constitution, but we all know what it means. Something that has to good standard, quality. If you see something that is good, if you see any enactment that is good, you will know that this is a good enactment. And if you see any ethos and pathos relating and a connection with what we make the labor force to be robust, or any labor law, of course, the court can make use of it. And that is why there is what I can describe as a paradigm shift from the common law principle of master and servant to what is now known as international best practices. I think I'm done for now. Thank you.
Well, so I'll just stay here. Again, a round of applause for the very profound insight shared by Dr. Otaru. Now, I'll need to give it to the CIPM president. The same question. Do you agree, sir? Or what are your thoughts on the international best practices, perhaps seen from the perspective of the human resources sector?
Folabi, you know that I'm going to come from the human resource sector. You are not going to hear sections, from me, and I'm not going to put it to you. So let us get straight to the point. The human resource profession believes so much in global best practice. In fact, without it, we are nowhere. We are not, yes, we are not an island on our own at all. We used to say that the world is a global village. No, in HR we now say the world is a global capsule. No capsule is as small as a capsule. Nobody winks in the dark. We are now boundaryless. These are HR terminologies to show that we benchmark with the best in the world. The initial thing from the HR to the National Industrial Court, trying to see it as a court that is tilted towards the employees, is the fact that some of us, Falabi, you will bear me witness, the last session where you were there and my elder brother, Adwale Jones, were there, you people turned it into a court, and I became the chief judge. So, is the fact that some of these, not knowing, some of us still don't know that once Nigeria is a signatory to these conventions, statutes, and so on, the court can begin to apply that. And because even 2-3 days ago, on our platform, somebody is still saying that even the paternity, the 14-day paternity, we have to be encoded somewhere in our law before it could be used. And I said, since Nigeria is a signatory, because I don't do much public chats, whatever you say is taken as the president of CIPM has spoken. So I go to the individual privately and said, I think this one has come to stay. Therefore, our take is that international best practices or global best practices is what we cannot afford not to adopt. We do it every day, not only in the area of law, in the way we manage our people. In employee well-being, we adopt international best practices. In our headhunts, in our talent search, we adopt these things because they do us good. And if we could adopt the good, in quotes, side of those, global best practices, those ones that are not too good also, we should be able to. Now, I can tell you that already practitioners have learned, because the fear of NICN is the beginning of wisdom. So those cases that have already been decided have become resources for us. We read those cases like no man's business, and we circulate. That's why CIPM, we've gone the education and the advocacy way to embrace these international best practices. So if you want to fire now, it's no longer enough to say services no longer required. We are there. That is why we go through thorough process. It is documented, and we are no longer afraid to put it there that this is the reason you are going.
Fantastic, sir.
And the person who is also exiting now, everybody is respecting him or herself. I will pause here because probably other questions.
Very eloquently said.
Thank you.
A round of applause. A round of applause. Well, I mean, you started by saying that you were not going to quote laws, but you ended up quoting the cases for us, almost like taking the job away from us lawyers. Thank you very much, sir. Very eloquently said. And it's good to know that we are all relating with international best practices. I mean, that appears to be response given to on first set of questions. So it takes me back to one important area where the local laws are insufficient or we don't have provision and travel abroad. Now, the starting point many a times for practitioners in that area, I mean, in this area, is to seek opinion. I mean, we've already identified a lacuna. You seek an opinion from international labor organization conventions. My Lord Honorable Justice Obasi, this question is for my Lord. And in some instances, some of those conventions, they refer you back, or they seem to defer to the national law. And I'll give an example on redundancy. The letters of the law, our local law on redundancy, is so bare. Very little said. So you try to perhaps consult the ILO Convention on Redundancy. Expect compliance. Okay, I think it's better. Yeah. Expect compliance with national law and practice for redundancy procedure. So that's all it says, that if you are to declare redundancy, comply with your local law. Now, the only national law on redundancy, generally speaking, is the Labor Act. Meanwhile, Section 91 restricts application to clerical staff. We discussed that. How then do employers comply with international standards? in those areas where none exists. I mean, international standard that is referring us back to the local laws. And then, will employees not be bound by the provisions of the Labor Act, be left simply to the provisions of contracts of employment? Thank you very much.
I don't know whether, no, it's not working.
Thank you. When all the ILO conventions, when you look at the articles, you look at the recommendations. The recommendations by the ILO Committee of Experts. You also look at the fact that there's a committee on standards in the ILO. The ILO doesn't operate in isolation. It respects the sovereignty of the individual states. So when it's talking about national laws, it expects that all member states that have signed up to these conventions will go back and enact laws that are in line with international best practices. So when we talk about national laws and redundancy, our Labor Act, yes, may be very old, but there is a provision on redundancy in Section 20. And that provision, as old as it is, still meets up with best practices. You will find that in most of the employee or employee handbooks or the contract of employment, where there's provision for redundancy, you will find that the employers have just lifted the provisions of Section 20 in the Labor Act. So we cannot say that we don't have any national law on redundancy, because the provision of the Labor Act gives the employer the procedure it is to follow when it declares a redundancy. And when it declares a redundancy, it must inform the trade union or employee association, or the employees, if there are no trade unions in that organization, of the redundancy and the extent of it. The provision also gives the employer the obligation to negotiate redundancy payments. In some of the contracts of employment or employee handbooks, you will see they have stated the redundancy payments the way it is going to be. But where the organization doesn't have that, the employer and the employee associations or trade unions must negotiate. And that is what is also known as social dialogue in the ILO. And what is the purpose of all of this? It is to ensure that employee rights are protected, because the main focus of the ILO is to ensure what it calls a decent work agenda. And even this provision for redundancy is part of that decent work agenda, that you can't just declare redundancy and ask everybody to go without paying anybody anything. So when it comes to redundancy, we have, yes, a law of maybe 1974, but it still meets best practice. And then, of course, what part of the question is, will employees, well, it says Section 91 of the Labor Act restricts application of the Act to clerical staff and manual laborers. How then do employers comply with international standards where none exists? It exists in our labor laws. So that has answered that question. But it says, will employees who are not bound by the Labor Act be left simply to the provisions of their contracts of employment? Yes, because the starting place, where you start from, is the contract of employment. So when there's an issue, for example, redundancy, we are talking redundancy now, you will go and look at the contract of employment. Is there any provision for redundancy? Is there a collective agreement? In most of the big in the industries, you will see in the collective agreements, there's always provision for redundancy. And this provision for redundancy payments has already been negotiated. And the fact of it being negotiated is a best practice. So where the employee is a managerial staff, or administrative, in the professional cadre, his contract of employment will make that provision. And where it does not make that provision, the employer must negotiate. And where the employer refuses to negotiate, then a dispute has arisen. And then what happens? The employee comes to court and says, this is my problem. And then a good lawyer will now begin. In the pleadings, will begin to plead international conventions, best practices. All these are questions of facts. So it is not entirely correct that the national law has not taken care of redundancy. And where the employee is in the managerial or administrative or professional cadre, his contract of employment is the place to go and to look at, because the contract of employment binds both the employer and the employee. Thank you.
Keep the hands. Another round of applause for my Lord for that beautiful insight. I'll go straight to my Lord Honorable Justice Adewale. This question has a bit to do with occupational safety and health, especially from the perspective of the employer. And he says that employers seem to constantly get the short end of the stick these days in the application of international best practices and labor standard. During the peak of COVID-19, employees refused to take the vaccine and also refused to be subjected to constant testing. Yet employers are required by law to ensure a safe working environment for employees. The ILO advocates social dialogue as a solution to this, but employees have remained unyielding and unbending. With the termination of an employee on grounds of refusal to vaccinate or be subjected to frequent testing or contributing towards the safety of the workplace be adjudged as discriminatory? Can employers mandate vaccination in view of the liability that may arise from an unsafe workplace? What options are open to employers? Are employers going to be given a leeway? My Lord, I know this might be in a very difficult situation because it can be a live case before the court. But for the purpose of this gathering, this is extrajudicial, and it's not necessarily the opinion of the court. The issue of, in that scenario, that case pattern, if you can hold the employer liable still for failing in his duty of ensuring safe working environment. Thank you so much.
Thank you very much. This nature of cases are actually live, so I will deal to the extent of. Thank you.
Thank you. Just as the HIV cases are also live, but this one deals with the safety at work. A scenario where, for instance, an employer leaves naked wires on the wall where you can easily get either a visitor or a staff of the company gets electrocuted by mistake, the employer has failed. So one would expect the employers to take better care generally. And now this talks about health. The employers are duty-bound to provide safe working environment for their workers. Now, refusal to vaccinate, it wasn't quite absolute. That was why the leeway or the room or the window for frequent testing was provided for. So it's either one or the other. Whichever one, the employers needed to or need to ensure that the environment is safe for work. Now, 100 employees in a building, 99 of them are vaccinated, or 95. The remaining 5 that are not vaccinated, the question is whether they pose a health hazard to the others. And I would say yes, because at the time these regulations were made, COVID-19 was an epidemic and we needed to be protected. It was a worldwide thing, and so I would say international best practices needed to be applied, and they were applied. I would say it will not be discriminatory to terminate an employee on those grounds. It's either you agree to be vaccinated or you submit yourself for regular testing. However, this can only be determined on a case-by-case basis because no 2 cases are the same. There could be circumstances, there could be exceptions, there could be dangers posed to an employee that makes it impossible for him to be vaccinated, and perhaps there are options, alternatives. For instance, if that employee is so important to the organization, you could give an option for remote work, and that was what was done in the Western world. And even here, at the crucial moments, people worked from home. Although it wasn't perceived as an alternative, it was still expected that everybody will be vaccinated. The other part asked whether an employer can mandate vaccination, and I would say again, yes. Of course, that would depend on the industry. For example, in the health sector, the nurses and the healthcare workers, they are at the front line. It would be most unheard of for them to refuse vaccination or testing. They are the ones that come directly in contact with the infected persons. And when they now say that they do not want to be vaccinated, they pose a health hazard to the other people. So in the health sector, it definitely would, the employer can mandate vaccination. There are many other sectors that would fall within this category, especially those that work in enclosed environments. But of course, again, we need to look at what the government policy says. Sometimes, like during the most crucial moments during the COVID-19 pandemic, there were various policies as it relates to who to go to work, who not to go to work, and all that. So by the time you apply the government policy vis-a-vis the mandatory need for vaccination, you might be able to, find that it becomes compulsory. Some people will say, I'm not traveling, so I don't need to be vaccinated. Maybe because, if it is because I will not be allowed to travel. But everybody was home. Nobody was traveling in those crucial moments. So you wouldn't really want to attach it to travel. In some government organizations, I understand they were not allowed to, if you were not vaccinated, you were not allowed in. Yes, those are quite reasonable policies of government, and I will align myself with it and say that if a person is terminated because he poses a risk to the other persons in the same working environment, then the employer has done the right thing. Because if the employer does not terminate such a person, he has failed in his duty to provide a safe working environment for the staff.
Thank you.
Thank you very much.
Thank you very much, my Lord. Thank you very much. And it's important, my Lord. No cases are the same. And everything will depend on the peculiar fact before the court. My Lord, we thank you very much for the great insight shared. And now I take it back to Dr. Otaro Essien. Again, well, I'll call it the practitioner's viewpoint, sir. The practitioner's viewpoint.
Okay, that's okay.
The practitioner's viewpoint on this. And maybe in saying that in the application of international best practices, one area readily stands out. I mean, earlier on, the CIPM president said that for HR practitioners now, the fear of the NICN is the beginning of wisdom. I think that's caution is often or more regularly, or the concern there, I think that's a better word. The concern is more of, if the company gets it wrong, the compensatory damages that may attend upon that could be as large or could be this, could be that. So that area stands out all the time. Compensatory damages that can come upon a successful outcome of a claim instituted before the court by the aggrieved former employee or worker, as the case may be.
Yes.
Doctor, I would like to hear your thoughts on the power that the court now has in relation to that exercise that enables, reliance on international best practices that allows the court to go push beyond what appears to be the settled frontier of common law, damages being limited to what it would have been entitled to and all of that. And then in response, let me also sound this as well, that are there any concerns around that area? Beyond your thoughts, I can almost predict your thoughts a bit. Are there any concerns around how that power is exercised?
Thank you. You see, the award of damages, like I mentioned it earlier, the case of Sahara Energy Resources Limited and Nba-Sbl, if you've gone through the judgment of the Court of Appeal, which is the last court in respect of labor matters, you discover that it has been stated time and time that the award of damages is on the discretion of the court. It all depends on the exercise of discretion by the court. And there is another angle to it, and that angle is the circumstance of that case. Because, for instance, in that matter, they said the employee's image has been stigmatized. So you look at the stigmatization of the image of the employee. If his or her reputation have been affected as a result of that termination or dismissal, it has a lot to do with the quantum of damages. And so, and there are provisions, even in the NIC Act and the rest of them, as regards the power of the judex to award damages. Like I said, it all depends on the discretion of the court and the stigmatization of the employee. Like, for instance, you mentioned it earlier, moderator, that the focus is on the wrong of the employer. The wrong of the employer. Because most times, an employer will just dismiss or sack an employee without a fair hearing. For instance, in that matter, the lady was accused of fraud because of what they describe as the feedback for customers. Now, during the proceedings, in fact, they had to prepare a charge as if it was a court of law. She appeared before the committee, and a member of the management committee also participated in that during the plenary of that committee. And at the end of the day, it was discovered that all what they said was not true. She was not even giving query, she was not giving query, and the rest of them. So the point that we need to know is that one depends on the discretion of the court, depends on the circumstances of the case, having regard to the stigmatization of the employee. That will affect the quantum of damages that has to be granted. And the court granted a 2 years salary in respect of it, although we claim salaries and the rest of them, but I also claimed general damages for breach of contract. And the court said, okay, yes, you have claimed that. Let me get out of the 10 million or 20 million for breach of contract. We give you 7 million, give the employee 7 million. So that is the situation as regards the quantum of damages depending on the wrong. Like I said, I refer to the provision of section 13, which talks about law and equity. Section 14, which talks about remedies, which a court can grant. And so, and of course, the section 19 of the National Industrial Court Act. So, when you put all these provisions together, at the end of the day, you discover that the judge, has the discretion to grant. If we, assuming we were ever given 50 million, that would have been okay, in line with international best practices.
Thank you so much, sir. I think you address the concern, but I'd still like to take it back. Still on that concern, you address the concern, and rightly so. Sorry, in referencing those sections of the Establishment Act, 13, 15, and 19. But again, I mean, I go back to the decision in Oaks Pension, which had been the currency before Sarah came on board. And there's this aspect, I mean, addressing that concern, there's this aspect, Justice Garuba, JCA, had said that, yes,
the Nasarawa case?
Yes, no, the Oaks Pensions case.
Oaks Pension,
yes. That I've been confronted, I've been told of Section 19, and I've read. But I must still, again, interrogate this in the light of the contract of parties. Almost like thinking aloud that can the statute, or should the statute now create a contract for parties?
Well, that's the
contract of parties have said that in the event of this is what you'll be entitled to, almost still tied to the
That's true.
common
You see,
position, yes.
there are also decisions of the Apex Court that parties can contract out of a statute. But with the promulgation of Section 254 of the 1999 Constitution as amended, I think, and it is a constitutional provision, and having regard to the provision of Section 1 of the Constitution, which I think, even though, because that contract for employment must have been generated from a particular law. So once it is inconsistent with Section 1 of the Constitution, I think, having regard to the fact that the Constitution is homegrown, what we lawyers refer to as auto channels, I think it will not fly, because there will be resort to international best practices.
Thank you so much. Thank you, sir. I mean, well said. A round of applause, please. Yeah. Yes, I go back to the CIPM president. Sorry, if there are questions, and we'll come to questions now, shortly. I mean, we just have 2 more questions. I mean, I take it back to the CIPM president, and the question is like this. The question focuses on the knowledge gap. We're having conversations around international best practices today. And there's this concern that even in the world of work, the representative of management or the employer, that is the HR, more often than not appears not to be up to date about what the law or what the position is in the world of work, about so many things in the world of work. And thankfully, you made reference to that the CIPM is actively reading the decisions of the court. And of course, I'm sure you would have seen in many of the decisions, the court will take time to even highlight that in the course of the evidence led, in rebuttal by the employer, the HR person who came up couldn't say much. Or I remember one notable one on sexual harassment, the HR person who came up to speak for the employer in that case and was asked that you're on the 3rd floor. The person accused was on the 11th floor with the person who was making the allegation. And so how did you come by this information? You were not on the same floor with them when it was, and then you could just barely say that, well, that's what I was told. So the question is, it would appear that there's a knowledge gap with HR practitioners continuing to apply outmoded employment principles in dealing with employees. For instance, despite the plethora of cases where the NICN had held that termination must be with reasons or that a dismissed employee must have been accorded fair hearing, and given an opportunity to defend himself or herself. These things are never done. Do you think it's a matter of knowledge gap? And if yes, what is the CIPM doing to bridge this gap? I mean, these are professionals that, you know.
Okay. Thank you, Barrister Folabi Kuti, SAN. I mentioned it earlier, what we are doing as an institute. And I want to say thank you again because in the last 18 months, I've worked very closely with you. You've even gone as far as introducing us to the president of the court, sincerely, and that's just a kind of the foundation for the collaboration we are looking at. The CIPM is neither for the employer or for the employee. The institute is for professional people managers. And what we have done is that we keep, can you imagine, since 1968, when the institute was birthed, and then we had an act of parliament giving us empowerment, not just to manage the practice of the profession, but to regulate. We have been reaching out to organizations, including organizations represented in this room. Earlier on, Tayo Opatayo came up, and I want to give kudos to that law firm. I think it's Akin Oyebola or Oyebola. You're on your own. Because for having a qualified professional at the helm of affairs. And this is what we have been doing via the advocacy route. Yes. That, you see, the problem is that some of these HR practitioners have refused to be certified. What does the certification platform give to you? Constant education and re-education. Constant on learning and relearning. That is what we do in CIPM. That is the platform we provide for our members. You have been on our platform severally at all levels. We have at the national level, we have the branches in all subnationals, and of course we have chapters. States like Lagos, Ogun, Rivers have chapters, zona, HR practitioners coming together to learn some of these things. And severally, these judgments have become, resources for us to learn. Therefore, what the appeal we are making is that whoever wants to practice human resource management must be certified. We are not just looking for members. We have value propositions for our members, and this is one of them. And we have conferences. I'm using one stone to kill as many birds as possible. Yesterday, this trip to Abuja, yesterday was the Abuja branch conference, and you needed to see the caliber of the faculty. So these are the things we do, because, if you do not train them, you cannot blame them. But I can tell you that the CIPM is well equipped. Now, one more thing. That having done advocacy these years, we are moving on to the regulatory level. And any moment from now, you're going to be seeing us. I won't use the word picketing because that sounds. So we are going to be working and collaborating with organizations. If you are not a certified HR professional, you cannot practice. By the way, HR profession is like medicine, it's like accountancy, it's like law, it's like architecture. If you find somebody who is not certified lawyer practicing, what do? You arrest him and you bring him before the court. So, but however, because we are people management, we have empathy and so on and so forth, we have done that over the years. Going forward, you will begin to show your certificate before you can practice.
Fantastic.
Thank you very much.
So much, sir. I mean, a lot has been said. A round of applause, sir. Now it's time for questions. Let me take you. There's one online that I'll read out, but here you, sir.
Thank you, my lords, the learned senior advocates, the organizers. My name is Nasiru Idris. I'm an in-house counsel in Premium Pension Limited. I have had discussion around the requirement that the National Industrial Code should give due regard to international best practices. Now, and if I understand well, the discussion centered around the convention of ILO, which could serve as a basis for the implementation of the international best practices. Then, assuming, are there other circumstances where you can have evidence of these best practices outside the ILO convention? And if so, what happened to conflicts? Should there be conflicts, maybe in a situation whereby some believe this is best practice and others believe this is not? Because there could be few instances where you find even the nations are not agreed upon in certain practices. So is there circumstances where you can find evidence of practice outside ILO convention? And if so, what happened to conflicts? Thank you.
Let's take the other question and then, yes, let's take, oh, okay, we have two more. My lord, would you want to take that question? Okay, yes. So please go ahead.
Thank you very much, sir. Thank you, ma'am. My question is for Doctor. He spoke about the damages that the NIC can award. So I understand that the general principle of law is that in contract of employment, the court cannot award exemplary damages. Yes, so, and I understand that in the case of Sahara Energy, what the court awarded was over 7 million naira as general damages. However, yes, sir? Yes, over 7 million naira as general damages. However, there's a provision in section 19D of the NICA Act that provides that the court can award any damages that it's deemed fit to be a compensation. So there are two arguments. One saying that, okay, NIC can come under that and award exemplary damages to litigants, where the other argument is that, no, NIC cannot do that. So my question is that, what is your position on that provision, on that particular section of the law, sir?
All right, thank you very much, sir. Any other, so that we can record all the questions and then we attempt. Okay, please go ahead, sir.
Yes.
Questions, comments?
Yes, and the question is for my Lord, Justice Obaseki, and I think it ties into what the gentleman from Premium Pensions mentioned earlier. It's really trying to find what's the limits of international best practice. So outside the ILO convention, and I asked this specifically because we had a situation recently where a multinational had acquired an entity here in Nigeria, and in reviewing the list of workers, it found out that the workers were primarily temporary workers. So out of, say, a number of 40 employees, about 34 of them are temporary. So where they are coming from, the jurisdiction where they are coming from, if you have a workforce that is composed primarily of temporary workers and a few permanent workers, it's not in line with international best practice where they are coming from. And one of the questions they asked was, we think this is wrong, right? It looks like the company is trying to avoid, paying certain benefits and things like that. And as far as they're concerned, there's something wrong here. But the question is, can we then look at something that is probably not stipulated in a particular instrument in another jurisdiction, or it might even be in that jurisdiction, let's say France, Germany, wherever? Can we then look at that and say, okay, listen, based on that, when we come back home here, that could actually form the basis for an assertion that the company is not complying with international best practices. Yeah.
Thank you very much, Ugonna. That was a beautiful question. Any other? Okay, so yes, my Lord, I'll start with my Lord Honorable Justice Obaseki Sage. I think two questions in one. The one on conflicts. Yes. And then still looking elsewhere. Whose best practice or best practices? Yeah.
Thank you. One of the questions is talking about international best practices outside the conventions, evidence outside the conventions. The conventions alone and the protocols and the treaties are not the only evidence of international best practice. Customs, practices in a particular industry, all those are evidence of best practice outside the conventions. So for example, maybe in the maritime industry, there's a particular custom that is applicable all over the maritime world. That is evidence of international best practice. So it does not necessarily have to be a convention. Customs, practices in the industries, and how you were talking about conflict. This party says this is the custom, the other party says that is the custom. That's why there's trial. And it is for the judge to hear both sides, evaluate the evidence, the preponderance of evidence, because in such cases, most likely, I am sure there will be civil matters. And the standard of proof in a civil matter is on the balance of probability and the preponderance of evidence. So where does this evidence preponderate? Where? Those are the conflicts we are talking about. So that is how the courts will resolve such an issue. On the issue of practices in other countries, you were talking about a company where they have so many temporary workers. That's evidence of permanent casualization. Permanent casualization. You just leave the staff there, temporary staff, for 2 years, 3 years. Of course, the country where, if it is a foreign company that is coming into work in Nigeria, the foreign company cannot be applying standards that are not in line with the standards that are operative in its own country. And then, of course, there's been a lot of talk about the issue of permanent casualization by the Nigerian Labour Organization. So that issue of permanent casualization is very sore. Even though our labor law has not said anything about it, look in other jurisdictions. This company, what is its status in the country where it is, in its home country? Is permanent casualization allowed? Are you allowed to have a temporary staff? Because you're talking about the numbers, you talked about 43. Are you allowed in that country to have a workforce of about whatever the number, and then 43 of them are temporary staff? For how long? Temporary staff, yes, temporary staff is not illegal, but it is the length. It is the length of time that staff is a temporary staff that questions the legality or otherwise. So you look at the home country. You see, one thing that we have to do, and council also have to do, is to protect our own workforce. You have a duty to protect our own workforce. What is not allowed in the home country should not be allowed here. It's not a question. You know, here we have a lot of issues. We have been talking about 1974 Labor Act. We cannot continue to work with 1974 Labor Act. That is why there's the provision for international best practices. So once it is not allowed in the home country, do not allow it here, and advise the client to please apply the standards which are better, international, in its home country here. Thank you.
Thank you very much, my Lord. Very well. Yes, my Lord wants to yet.
Yes, just to add to what my Lord just said, there are unfair labor practices that thrive, and those are part of what the international labor standards seek to address. There are so many such unfair labor practices, and it will be the court that will probably determine, even if it is not pleaded, depending on the circumstance. As I said earlier, each case has its own merit. The circumstance may warrant a court to pronounce a particular act as an unfair labor practice. Some contracts of employment are obnoxious, fashioned to completely stifle or gag the employee, and even sometimes take away his constitutional rights. Those kind of contracts of employment, will you now say that that contract of employment is what will determine how it goes? The court has a discretion in that circumstance to jettison that contract of employment and use international labor standards to determine that matter. That is to say, to conclude that that contract of employment is not in line with or contravenes the international labor standards. And in most cases, it's the litmus test is to determine how reasonable a scenario is, that will warrant the application of an international labor standard. It may be just a completely unreasonable scenario. For example, a scenario where some of them are life cases, I'm afraid, but sometimes you cannot do without throwing in one or two, where a person is prevented from being pregnant because you are in unemployment. That doesn't sound reasonable. So wouldn't that be a contravention of, and there are labor standards to that effect. There are ILO conventions to that effect. But what are you doing that would, especially in the light of the Constitution that provides for, or even a scenario where a person is dismissed or terminated because he belongs to a labor union? He has a right to freedom of association. So why would you, there are so many of such scenarios, they are numerous, but each one can be determined on its own merit. And it is the facts of the case that will determine the reasonableness of the situation to warrant a decision one way or the other.
Absolutely. Thank you so much, my lord.
The chap that asked that question, that was a very good question, but I will answer your question, but go and read the judgment of Sahara Energy Resources Limited and Oyebola. That point was raised in that case. The appellant raised that point. That, why you awarded, instead of 1 month salary in lieu of notice, look at the condition of service, look at his letter of employment, you awarded general damages. And the simple thing, both the trial and the appellate court said, look, that one belonged to the days of yore. That is a common law principle. And having regard to the provision, the new provision of the Constitution section 254C, F and H, general damages can be awarded, not 1 month salary in lieu of notice. And especially where the court has to, the court stated emphatically that the lady has been stigmatized. She has been rubbished as a result of that trial and the letter of dismissal that she committed fraud and the rest of them. So, cases that were decided before the third alteration, yes. The court stated, the court appeal stated that after the alteration, the third alteration, damages can be awarded by the National Industrial Court have predicated on international best practices and standards. Thank you.
Thank you very much, Doctor. Well, you no doubt agree it's been a very engaging session. We could have gone on and on. But we have to bring this to a close now. I thought we could attend to questions online, but apologies that we're not able to take questions from those online. We need to bring this to a close. So I would be inviting Mary also to come and say a big thank you to the distinguished panelists that we've had today. Thank you so much.
Thank you so much, Mr. Kuti. Thank you, my lordships. Thank you, sirs, for your time. We'll take a picture, and then we will pretty much call it a day. But let's take a picture first. I will do vote of thanks, yes. Thank you very much. Thank you. I know. Almost. Thank you very much for coming. Thank you so very much. Thank you. Thank you all very much. With this session, we have come to the end of our event. We will go to lunch from here on behalf of the planning committee. If the members are here, could you come up? We'd like to say, yeah, if all the members of the planning committee are here, Natalia, Jamiu, Dolako, planning committee, would like to publicly acknowledge you if you could come up. Thank you. Thank you for the incredible amount of work that went into doing this. Max, are you here? Thank you. I certainly couldn't have pulled this up without the support of this amazing ladies and gentlemen. Thank you so very much. Chisom, I know you're online. Thank you very much. We couldn't have done this without you. And of course, Mr. Kuti, thank you all for your time. Lunch is served. We will have lunch just right outside. Thank you so very much for your time. Have a good day.
The land is green. It's green. Oh, oh.